1 and 2, Lordship, I pay for 3 weeks time, also we'll file objection, Lordship.
But one is for motion.
Lordship, 1 and 2, Lordship.
We can issue notice.
Lordship, may
Let
issue
it be
notice with Lordship.
That formality part we can.
Lordship.
What about the division bench?
That is, your lordship will have to take up, division bench will take up this matter.
Oh, that was the order which was passed sitting single.
Lordship.
Now it has come before the division.
Lordship.
This criminal appeal 120 has now been renumbered as criminal revision petition.
Lordship.
This petition was initially presented as an appeal under Section 21(1) of the National Investigation Agency Act 2008, whereby an order dated 22/10/2024 passed by the learned special judge, National Investigation Agency, Kamrup M, in NI case number 2 of 2020 arising out of so and so, was put to challenge. Subsequently, the criminal appeal has been converted to a criminal revision petition. Let notice be issued. 3. Here you go. You appear as what?
As a Lordship, special PP Nia Lordship, NI.
Special PP Nia NI is present for the respondent and prays for time to file objection.
Lordship.
List
After 3 weeks or 4 weeks, Lordship.
list after 3 weeks.
Lordship.
To enable filing of such objections. The second one will be the same?
Same.
Same.
Yes.
Second same. Number change हो सकता है, देख लीजिए. Yes, item 3.
So your lordship, you will have to come this side. It's there actually.
He Lordship, after vacation, Lordship.
21 matters.
After vacation, Lordship, because today, Lordship, we have some difficulties, Lordship. The file also not come with the Lordship water logging. The office.
Limit on the water.
Lordship.
Limit on the water.
Not only that, Lordship.
Limit on the rain.
If it is not inconvenient for your lordship, on 28th of October, your lordship.
Okay. A prayer for adjournment has been made on behalf of the appellant, which is not opposed by Sri. A prayer for adjournment has been made by Sri K. Gogoi, learned special PP NI for the appellant, which is not opposed by Sri S. Bothakur, learned counsel for the respondents. Para. In view of the above, matter stands adjourned to be listed on
28, Lordship.
28th, your lordship.
28th of
October.
Yes, 28th of.
Lordship. Oblige, Lordship.
Division bench to same special division.
Lordship. Oblige, Lordship. Deeply oblige, Lordship.
May I please, Your Lordship? I beg to mention, actually, I am beg to mention for listing a GST cancellation for motion.
Motion,
File.
when do you want?
Oblige.
When do you want?
21.
When do you want? Which date?
Immediate, Lordship.
When did you file?
It's filed yesterday.
Yesterday. You can have it on Friday? Or
Oblige.
yes, Friday?
May please, your lordship, this matter has been, this matter has been fixed to, tomorrow, lordship, before this court, your honor. And on the earlier occasion, when the matter was fixed on the 5th, 9/2025, I was directed to file an IA for correction of procedural of the, amendment. I have already filed the IA, but that has not been listed
Will
with
get the IA listed tomorrow along with the main petition?
deeply obliged, lordship.
May I proceed, Lordship? Lordship, I beg to mention for listing a matter.
For?
For my lord. 24 matter,
Oh?
land matter,
Now, what stage? What is the stage?
orders.
What is the urgency?
Urgency, my lord, the lady is 61 years, my lord, he is approaching the district commissioner many times, my lord, for
There is no
30.
urgency. Out of turn listing of orders or admission has to be has to be urgent. There has to be urgency.
Aye.
Motion matters are different.
May I please, your lordship? Lordship, I beg to mention item 14, lordship.
1-4.
Yes, your lordship. Lordship, there is a waterlogging. Dr. Saraf won't be available.
Where you name a place in Guwahati where there is no water logging.
Yes,
That is the day, call of the day, every day it's water logging.
yes, your lordship. Short bit, maybe.
Huh? Short day. You could come, I could come,
Yes, your lordship.
others have also come.
Yes, your lordship. But there's a heavy flooding.
Hmm?
As if there is a difficulty, lordship.
14.
Yes, your lordship.
This matter, we could have done it today.
Yes, your lordship. What? No, item 14. So we're ready with the matter, but there's a problem.
In fact, this needs to be, I think, referred to the division bench.
Yes, your lordship.
That retrospective.
Yes, your lordship.
What is the financial year?
Yes,
We have
sir.
gone through. Okay. A prayer for adjournment has been made on behalf of Dr. Ashok Sharaf, learned senior counsel for the petitioner who could not come to the court because of water logging.
Yes, sir. Inform the other side.
Considering the above comma, matter is adjourned to be listed. When?
Next week, any.
Day after tomorrow,
Yes, sir. Thursday, lordship.
Thursday, on Thursday.
Oblige, your lordship.
Considering the above, as well as taking note that this petition is of the year 2015, a slight accommodation is granted directing listing of this matter on Thursday.
Lordship, for item 1 also, we have to respond in lordship.
One,
Yes, sir. Yeah, for the.
one that Mumbai matter.
Yes, sir.
Here's for state of Maharashtra.
Yes, sir.
There is another council for Maharashtra.
For the second item, your lordship.
Huh?
Second item.
You're from Maharashtra, isn't it?
Yes.
In one of the cases. So what do you do? Thursday we'll try or when?
Thursday, Your Lordship, because there's been a stay operating for a long time.
Yes, sir.
We'll try on Thursday, okay? The same. Dr. Saraf appears in which matter?
Item 1, your lordship. Amar
Okay.
Shakti.
Amar Shakti,
Okay.
the first one.
First one.
On behalf same prayer, water logging. The last column of likhe. Considering the above,
Petitioner.
these matters are adjourned to be listed on Thursday. Is it okay?
Yes, Your Lordship. Petitioners are not there. though.
No, then let the matter be called.
Yes, sir.
Okay.
Maybe he's also stuck in water logging. Mr. S.N. Tamuli,
He is on the way, Lordship.
we'll have it on Thursday, okay? He's coming by a boat or what?
Lordship is adjourned. I
Yes, Thursday.
Obliged.
1 and 2.
Yes, sir. For Thursday, Your Lordship.
Yes.
May I please, your lordship? On last occasion, your lordship had fixed the date that was yesterday, but unfortunately matter listed today, your lordship. In this case, your lordship, on 1/1/2022, husband of the petitioner, your lordship, namely Jade Tudu, had expired due to attack by wild elephant, your lordship,
Where is forest?
while he was
Forest is required lordship.
Forest.
What?
Let us have this after a while. That for. Yes,
Can it be passed over for 10?
time being, yes.
Please, Lordship. Lordship, on last occasion, this honorable could direct us to file and written states instructions regarding the demolish, Lordship. Accordingly, we have communicated with our petitioner, Lordship, but that instruction is awaited. So I am preparing for some time, Lordship.
My lord, the time may be granted at the same time, my lord. This honorable court call for a report of the circle officer, my lord. On my lord, complaint, my lord, the measurement was done, my lord, and municipality asked for the same, my lord. But till that, my lord, not produced. My
Yes,
my lord,
Mr.
that being.
Goswami.
No, that is not received.
Hmm?
Not.
Mr. Sahiwala, you are referring to which order?
My lord, 27/1/25. And municipality letter, my lord, at page 113, my lord. Isn't he? First parameter. And measurement has been taken on page 113, you will also see, my lord.
Yes. You had lodged a complaint.
Complaint, and they have already, my lord, measured, my lord, page 113, my lord, you lost it, just 3, my lord. 113.
A prayer for, no. What is your name?
MM Zaman, Lordship.
MM?
Zaman.
You are not on, yes, free. MM Jaman, learned counsel for the petitioner.
On
But-
behalf of Mr. S. Samaria,
No,
Lord.
you are there on record.
Lord.
Learned counsel for the petitioner, comments by referring to the order dated 5/9/2025 has submitted that some more time would be required to obtain the written instructions.
Lord.
Full stop. Three. Sahiwala, the learned senior counsel for the respondent number 5 has also referred to the order dated 27/1/2025 and has submitted that instructions by the state council was also required to be obtained. Full stop.
Regarding report of a circle officer, my lord.
In the form of a report from the circle officer.
We have communicated, lordship, but
Where is it, circle officer report?
my lord, if you lordship see page 113, my
Oh,
lord.
no, let him have the instruction. I will not say in the report.
Yes, report has not come.
From the state council from instructions, correct? In view of the above, the consideration of this matter is deferred by 2 weeks. 2 weeks to enable the respective council to obtain the instructions. Okay? List immediately after the autumn vacation.
You believe us.
Tomato?
I think it's really timely.
Yes, you will appear for the forest department? Yes, what is it?
Here, my lord, the petitioner is demanding an ex gratia by virtue of a notification, my lord, where ex gratia is awarded to victims of wild animal attacks. But my lord, the exception is that if they are found to be encroached inside forest, my lord, they are not eligible for this scheme. And unfortunately, my lord, the petitioner was found to be inside the reserve forest, my lord. So that is why the DFO's finding was that he will not be eligible for that ex gratia.
May I please?
Yes, what is your case?
Yes, your lordship. Lordship, in this case, petitioner belongs to traditional forest dealer community, your lordship. And
What is it, traditional?
belongs to your lordship, the forest dealing, your lordship, as per the affidavit filed by the respondent number 5, your lordship. Petitioner belongs to traditional forest dealer, your lordship.
Forest?
Traditional forest dealer.
Dealer?
Yes, lordship.
What dealer?
Dollar, your lordship.
Huh?
Forest dealer, your lordship.
Dweller?
Yes, your lordship.
You
What
should
is
know how to pronounce at least. Don't say dealer.
Yes, lordship.
How
Forest
can a
dealer.
dealer be a dweller be a dealer?
Yes.
What is the meaning of dweller? Do you know the meaning of dweller?
No.
You don't know. You have not even bothered to know the meaning of dweller. And your case is entirely based on that expression, dweller.
And according to the your lordship, ST tribe and others traditional forest dealer acts, your lordship 2006, the petitioner is entitled even though they are enclosure, your lordship.
Under which?
ST tribe and others traditional forest dealer.
Where do you get?
Yes, lordship. Top of button, your lordship. A. Right. Lordship got it?
Yes, yes, the scheduled tribes and other traditional forest dweller recognition forest rights act 2006. Which section?
At phase, second phase, your lordship. 3(1)A, your lordship. The right to hold and live in the forest land under the individual or common occupation for habitation or for self-cultivation for livelihood by a member or members of a forest dwelling scheduled tribes and other traditional forest dealer, your lordship.
Yes.
And as per their affidavit, your lordship, petitioner belongs to that community, your lordship, other traditional forest dealer. Your
Where have
lordship.
you stated?
If your lordship will take affidavit filed by the respondent number 5, your lordship,
Now, where have you stated? What is your status?
paragraph number 4, your lordship. Line number 12, your lordship, paragraph 4. May I read, your lordship?
Affidavit by?
Lordship,
Affidavit by whom?
Respondent number 5, your lordship, DC. District Commissioner of Court. Page 38. Paragraph number 4.
Paragraph
4.
4.
Yes, lordship.
Yes.
Line number 12, your lordship.
Hmm. Please read.
Page 38.
Yes. Please read.
Yes, lordship. Lordship, may I read from
Yes.
paragraph 4, your lordship, that while the matter came up for consideration before the honorable court's order, after hearing the parties and on being placed, the communication dated so and so sent by the additional deputy commissioner Koprajar inter alia stated that the divisional forest officer Holtugao forest division had been directed on so and so for sanction of ex gratia grant to the petitioner, namely Bahamurgu. In this connection, the divisional forest officer, Holtugao Division Forest, Koprajar submitted a report dated so and so regarding sanction of ex gratia. The report dated so and so inter alia stated that the petitioner is the next of kin of the deceased person and a family member of Longsung Koddomguri Gao Sabha, Gram Sabha under village number 2, Dharampur, and belongs to other traditional forest dealer. The report stated that the petitioner is not a regular forest dealer and is not legally authorized to the present inside the forest. In this paragraph, your lordship, the contention of this respondent number 5 has the petitioner, though enclosed that they have belongs to the forest additional dealer, your lordship. So as I submitted already, as per the Forest Right Act, your lordship, the petitioner has the right to reside the forest land, your lordship. So according to that, my your lordship, the petitioner prayer may be considered as per the notification issued by the Forest Department, your lordship.
Let us see the notification.
Yes, lordship, 36 at page 36, your lordship.
No, the notification of
36,
your
your lordship.
entitlement.
Principal Secretary to the Government of Assam Environment Forest Department, Dispur Guwahati, your lordship, issued them. At page 36, your lordship, serial number 1, ex gratia payment to families of deceased persons. First, serial number. Petition.
Yes.
Yes, lordship. Paragraph number 6, your lordship. Enhancement of ex gratia / compensation for loss of human life and injuries / damage to crop and properties caused by wild animals, your lordship. And our claim is for the serial number 1, your lordship, because husband of the petitioner had expired due to attack by wild elephant, your lordship.
When did the incident take place?
On 1/1/2022, your lordship, while he was sleeping at his residence, your lordship.
Okay. Yes, Mr. Waterford.
Yes. My lord, may first, my lord, responding to that paragraph, my lord, which my learned colleague had relied, the affidavit submitted by the Deputy Commissioner, my lord.
Yes. Mr. Akand,
This is based on-
have your seat, Mr. Akand.
Yes.
Have your seat. Yes.
This paragraph, my lord, is based on the DFO's report, my lord, which my lord will find at page 42, running page.
Yes,
Running page is page 42.
yes, he has just read paragraph 4.
Paragraph 4, my lord, yes. Sufferer of wife, so and so is the next of kin of deceased person and a family
We have
member.
read this.
Yes, my lord may see this line, my lord, which is under process for FIRA title. It means, my lord, a Forest Rights Act title. What this essentially means is that my lord may see the act that was given to your lordship by my learned colleague, the Act of 2006. In that act, my lord, there is a section 6.
Yes.
Section 6 says, my lord, authorities to vest forest rights in forest dwelling scheduled tribes and other traditional forest dwellers and procedure thereof. The Gram Sabha shall be the authority to initiate the process for determining the nature and extent of individual or forest right. So, my lord, this process is being mentioned in this paragraph 4 of this document, my lord. So, until now, he hasn't been recognized, the deceased hasn't been recognized as a forest dweller. So, the status is that of an encroacher because this process is not complete as required under the Forest Rights Act of 2006. So, that is why, my lord, our instructions is that since the status is that of an encroacher, this may not be awarded to the petitioner's husband, in the name of petitioner's husband only.
But the ADC in her affidavit
Yes.
has termed his as other traditional forest dwellers.
Yes.
Why is this expression used?
This this is the phrase that is used by the officer, my lord, but it clearly means that the process of it is still under process and they are not yet recognized as a forest dweller.
Do you
Because
have, Mr. Akan, do you have any certificate by the Gram Sabha determining your rights or recognizing you as an other traditional forest dweller? That is not there.
I've not discussed with about that. With
That
them.
is not there. But only for that formality, if he is otherwise entitled to, he should not be deprived.
my lord, our only concern is that, my lord, will this open a Pandora's box and encourage encroachment, my lord? Because if
No, it's not that question. We are not on the Pandora's box. We are on the aspect that if a genuine person who is a traditional forest dweller, he can hold
yes,
land, live within certain restrictions. But there is also a caveat in the form of Section 6
yes,
that such recognition has to be done by a particular authority, namely the Gram Sabha.
right.
Now you say that the Gram Sabha is not there.
Yes,
So even first, this is not part of his pleadings.
yes,
That is other, but your affidavit in opposition by as per number 5
yes,
brings in the aspect of he being a member of the other traditional forest dweller. But the recognition part is still there. So what we are thinking that why this exercise should have been done to determine whether he falls under this category. In
Yes.
that case, who are the parties here?
Your lordship,
Is the Gram Sabha party?
no,
Panchayat?
no, lordship.
See, Mr. Akant, with this petition, we cannot grant you relief, but we can grant you the liberty to apply for such a certificate. And if such a certificate is there,
then yes,
and if such certificate is there, then you cannot raise any objection. Okay?
that can be done.
Heard. Sri S.I. Akant, Learned Counsel for the petitioner. Also heard Sri I. Bothapur, Standing Counsel Forest Department, whereas the state respondents are represented by Sri N. Goswami, Learned State Counsel. Para. Please have your seat. The approach to this court by the petitioner is with a claim for ex gratia oblique compensation in terms of a government notification dated 6/3/2017. Full stop. Para. It is the, as per the facts projected, comma, the husband of the petitioner, Chade to do, oblique, alias Thade to do, dekh lijiye, was attacked by a wild elephant in his house on 1/1/2022, as a result of which, comma, he had expired. Full stop. The matter was reported to the police, and Bishmuri Police Outpost GD number 20 was registered on 2/1/2022, and subsequently Kokrajhar PSUD case number 1 of 2022 was also registered. Full stop. As a notification dated 6/3/2017 for payment of ex gratia was in operation, the petitioner had applied for such ex gratia, which was not acted upon, and thereafter, and therefore, the present petition was instituted for Riakan, the learned counsel, has submitted that the notification, which was published on the Gazette on 6th March 2017, prescribes for ex gratia payment to families of deceased persons of rupees 4 lakh. Full stop. He has submitted that the said notification is for loss of human life and injuries, including damage to crops and properties caused by wild animals. Full stop. He submits that the inaction on the part of the respondent authorities, in spite of being eligible for such ex gratia, amounts to illegality, and therefore this court may issue appropriate direction for release of such payment. Full stop. Para. The learned counsel has also drawn the attention of this court to the affidavit in opposition filed by the respondent number 5 dash District Commissioner, Kokrajhar, on 26/6/2023, wherein it has been stated that the deceased belongs to other traditional forest dweller, within bracket OTFD. Full stop. He has also drawn the attention of this court to the scheduled tribes and other traditional forest dwellers, bracket recognition of forest rights, bracket close, Act 2006, and has contended that other traditional forest dwellers are entitled to hold, entitled to, amongst other, hold and live in a forest land. Full stop. He has drawn the attention of this court to section 3(1)(a) of the Act to buttress his argument. Full stop. He has submitted that when the respondent number 5 has admitted that the petitioner belongs to the other traditional forest dweller, within bracket OTDF, OTFD, there should not be any hindrance or barrier for release of the amount in question. Para. Per contra, comma, Sri Botakur, the learned standing counsel Forest Department, has submitted that the application of the notification dated 6/3/2017 for payment of ex gratia has to be with regard to death or injuries caused by wild animals which is outside the forest area. He has submitted that the area in question is inside which forest?
It's inside
Haltu.
Haltugaon Reserve Forest. Madam.
Haltugaon.
Yes.
Haltugaon Reserve Forest in the district of Pokrajar, and therefore the notification would not be applicable. Full stop. On the contention that the petitioner is a traditional forest dweller, comma, the learned council, learned standing council has submitted that the aforesaid aspect was not even pleaded in the petition and had come to surface only on presentation of the affidavit in opposition by the respondent number 5. Full stop. By drawing the attention of this court to the averments made in paragraph 4 of the said affidavit, comma, the learned standing council has submitted that though there is a reference to the petitioner to belong to other traditional forest dweller within bracket OTFD, comma, the report of the DFO also mentions that the petitioner oblique deceased would still be an encroacher till the issue of FRA title, if eligible. By drawing the attention of this court to the Act of 2006, comma, more specifically, Section 6 thereof, the learned standing council has submitted that the authorities and the procedures for vesting of forest rights have been laid down in the said provision. Full stop. It is submitted that it is the Gram Sabha which would be the authority to initiate the process of determining the nature and extent of individual or community forest rights, or both, that may be given to the forest dwelling scheduled tribes and other traditional forest dwellers. Full stop. Admitted, full stop. He accordingly submits that unless the unless the deceased oblique petitioner is recognized as a traditional forest dweller in the manner prescribed, comma, such ex gratia payment cannot be given. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. The claim in this petition is primarily based on the notification dated 6/3/2017, as the husband of the petitioner was killed by wild elephant on 1/1/2022. Full stop. It is, however, not in dispute that the deceased was residing inside the so-and-so reserve forest. Full stop. This court has noted that it was not the pleaded case of the petitioner that the petitioner oblique deceased belongs to the traditional is a traditional forest dweller. Full stop. However, the said aspect came to be disclosed in the affidavit in opposition filed by the respondent number 5, dated 26/6/2023. And the relevant aspect is extracted herein below, page 42, paragraph 4. Full stop, paragraph. The power exercised by this court under Article 226 is equitable in nature, and therefore the strict rules of pleadings may not be applicable, as in the affidavit in opposition, the aforesaid aspect has come to light, wherein the respondent number 5 has stated that the petitioner /deceased belongs to other forest dweller within bracket OTFD, full stop. However, the said finding is based on a report given by the Divisional Forest Officer, Altungao Forest Division, which contains further aspect that the petitioner /deceased is an encroacher unless FRA title is issued. Full stop. This court has considered the submissions advanced by the learned standing counsel Forest Department that under Section 6 of the Act, both the authorities and the procedure to be adopted for vesting of forest rights have been laid down. For ready reference, Section 6 is extracted herein below. This is 6. Admittedly, in the instant case, there is no such recognition by the authorities prescribed, and therefore this court cannot come to a conclusion that the deceased petitioner is indeed a traditional forest dweller. Full stop. In view of the aforesaid findings, this court is unable to grant any relief to the petitioner. Full stop. However, the petitioner would be at liberty to apply before the appropriate authority under Section 6 for issuing certificate of such recognition, and thereafter submit the same before the forest authorities for the grant of ex gratia. Full stop. It is made clear that if such a claim is accompanied by the certificate by the authority under Section 6, the same shall be entertained and the prescribed ex gratia be paid to the petitioner without any delay. The petition accordingly stands disposed of.
Obliged.
So obliged.
Yes.
Please, yes, my lord. My lord, will recall, my lord, it's the matter where the land was taken over by the state on the promise that a particular amount would be paid, my lord. Thereafter, they said that they will not pay as much because the zonal valuation of tea land has gone down.
We don't remember.
my lord.
Yes.
Now, my lord,
Yes, madam. Very pensive. Why are you so pensive?
Lordship, here we.
You-
the
you seek time.
PWW was-
Therefore, you are pensive. Should be very happy you are seeking time because the court is not granting time.
Lordship, only 2 weeks, Lordship, short date.
my lord, may I just clarify one thing? My lord? What has happened, my lord? We had placed a judgment on 13/6 while the matter was heard. It was a judgment by a coordinate bench, Pankaj Mohan, my lord. This took time to seek instructions as whether that judgment would be applicable and whether that has been appealed, my lord. We could not find any, my lord. Then they again 3 successive dates. That's the ground on which that's the limited instructions that they want, my lord. Otherwise, pleadings are complete. So, my lord, even if we don't rely on that judgment, perhaps the matter can be taken up, my lord.
No, there is a judgment by the coordinate bench. Why should we again
My lord.
go for a decision-making process exercise? We'll follow the judgment.
Lordship, then let my senior come and apprise the court.
Matter has been adjourned a number of times. See? Pankaj Mohanian. Yes, when can we have? Matters are listed to with the intention to dispose of on a Thursday or a Tuesday. When can we have? While Sri B.D. Dekar, Learned Counsel for the petitioners is present, comma, Miss
H. Burma.
H. Barua, Learned Counsel appearing on instruction of Sri P. Nayak, Standing Counsel PWD,
PW.
prays for some accommodation. Para?
Can it be next week, Lord?
Next week it will be difficult, last week. We'll have to go after the vacation. List for admission hearing on 23rd of October. 23rd October we'll finish the job. 23rd Thursday.
We'll observe that.
Well, on which date an endeavor will be made to dispose of the reparation.
Obliged.
Much.
I am for the state responding.
Okay. We, Muslim, Learned Additional is present for the state.
Maybe Lordship, my senior is now out of station, my lord. Oh,
Senior is out of station.
yes, my lord. Item number 6.
Where has he gone?
My lord,
6 and the others, Mr. Bothakur is there.
Lordship is engaged in another matter.
Yes, what are these matters, Mr.
Your
Pathak?
Lordship, these matters, the petitioners are prima facie challenging the acquisition of their land. In some cases, Your Lordship, the stand of the government is that they are illegal encroachers on government land. So under the land policy, they may be accommodated elsewhere. And the land otherwise is sought to be acquired for a thermal plant to be constructed by the APDCL
There is a status quo,
in one matter.
but all are related to the same area.
Same project, same. The
do you
revenue
do?
department.
Mr. Nath Malati legs.
DNAT.
Otherwise, the tender has already been floated by APDCL. The last date of submission is on the 3rd
Tender for?
for construction of the plant for the work.
What is your case?
we have already affidavit filed, my lord.
Who is your senior?
And is Mazhab, my lord. My lord, item number 6.
What can we do? Day after tomorrow?
Very good.
Day after tomorrow?
Yes.
Okay.
Apply.
A prayer for adjournment has been made on behalf of
Well,
Sri N.H. Majurvia.
My senior is now out of station, my lord, for his medical treatment, my lord.
Okay.
Hello, my lord.
If it is not day after tomorrow, then we'll go after the vacation.
Some urgency on that.
Urgency is there.
Otherwise, I appreciate his difficulty, but
When is he coming back?
After 2 weeks, my lord.
What do you do, Mr. Pathak?
perhaps
In his case, there is a stay order.
item number can be.
Item number 6, my lord.
I don't think in this matter there is a stay order.
Then
I think in Mr. Bothakur's matter, there is a stay.
you go ahead with it because
Yes.
you go ahead.
Yes, we are otherwise.
Construction will take a long time. We will be
Wait.
writing bids and all this. Okay, we'll have it after the vacation. A prayer for adjournment has
Our
been
Lordship may
made.
perhaps fix it on Wednesday and otherwise the revenue may
Next Wednesday,
this coming Wednesday.
tomorrow.
Yes, Your Lordship.
Tomorrow he's not there.
Perhaps so. The revenue might have some instruction or if they are accommodated elsewhere. Then perhaps that can be the resolution of. Because as per the land policy, they may not have a right to stay at that location. But if they are accommodated elsewhere. Or if Mr. Nath, Lordship will have it after some time. Mr. Nath.
Okay.
Yes, Mr. Nath?
Well, the affidavits and the pleadings are complete. And some urgency is there on our part. If they have some inconvenience, kindly give us a date on day after tomorrow, Malad, if possible.
He is gone for some medical treatment. Mr. Major Bhuya. So we would have given fixed day after tomorrow, but he'll come, he's praying for next week. Next week will not be possible. Next week will be the last week before the vacations. So it has to go beyond the autumn vacation. There are no stay orders. You go ahead.
In one case, there is, Malad.
No, see, you want to
That-
have a project of APDCL.
Yes, Malad.
You can go for calling for bids and all those things. Okay.
Not-
Personal, but medical, okay, now, but next time if there's inconvenience, you have to make alternative arrangement. Medical reasons we're granting adjournment, but urgency expressed by the other side is also, will also have to be considered. A prayer for adjournment has been made on behalf of Sri N. H. Madhur Bhuya, Learned Counsel appearing in WPC 2350-2025 on medical grounds. The other matters are connected. Both Sri D. Nath Learned Learned Senior Advocate and Sri K.P. Pathak Learned Standing Counsel APDCL have expressed urgency as the land in question is proposed to be utilized for a project of the APDCL, correct?
Yes, Your Lordship.
Lordship.
Considering the above, while the matters are adjourned, the same are directed to be listed on 14th. 13th you are evening, 14th.
Lordship.
14th, okay?
Lordship.
On which date an attempt will be made to dispose of the writ petitions.
Malad, can I pray for an observation that in the meantime, they will go ahead with the other things, Malad?
Is there any restriction?
Yes.
No restriction. There is no restriction.
Except for one. In one matter, there is an observation. I think you can keep track.
Other, there are no observations. Why are you inviting this now?
Lordship. Malad. Lordship.
Yes.
Oh, Malad.
Your Lordship. This was released to the cremation ground, Lordship. So the respondent number 6 to 11 has filed a reply, Lordship. Other respondent are yet to file a reply.
Lordship, I have received the Paravise copy, Lordship. It required 2 weeks time to file my affidavit.
Who's for 6 to 12?
Plus Kampura and other private.
Who's the counsel?
M. Ahmed. M. Ahmed.
Oh, you are R.J. Sharma?
Lordship.
Sri R.J. Sharma, learned counsel for the petitioners, who has informed that while the respondent number 6 to 11 have filed affidavit in opposition, affidavits, two affidavits in opposition, comma. No, while the respondent number 6 and the respondent number 7 to 11 have filed separate affidavits in opposition, the state is yet to file the affidavit. Para. Through S.S. Roy, Learned State Council has submitted that instructions have been received and the affidavit would be filed shortly. Para. Shortly, and accordingly he prays for some time. Para. In view of the above, consideration of this matter is deferred and the matter be listed for admission after the autumn vacation. Before the next date, comma, the state government is required to file the affidavit.
The interim order is there.
Interim order passed earlier to continue till the next date of listing. Yes, Madam Ghosh.
Please, Your Lordship. On last occasion, interim order was passed, Lordship. She is an acid attack victim.
Okay.
She received that compensation. Now she requires for her medical treatment,
Yes,
Lordship.
Mr. Roy.
Lordship, I have informed that some assistance has already been given to her. Now, up-to-date instruction on the last occasion, it was directed.
22/8 was the last date, isn't it?
Lordship.
Yes.
In fact, that was the first date. Notice was issued. Notice
Yes.
was issued.
Thereafter, Lordship, I have not received the up-to-date instruction what had happened, Lordship.
You get the instruction.
Lordship.
Yes, she
This
has.
is the instructions you have got.
Yes,
Miss-
she has received that victim compensation that I have also stated in my petition.
Ms. D. Ghosh, Learned Counsel for the petitioners, has submitted that the victim compensation prescribed for acid attack victims has been received.
Yes, I have stated.
However, the expenses for medical treatment,
An additional 1 lakh rupees for per victim. This is under the central government law.
you have received.
Now that we are yet to receive. We have received that, we have stated also in page 11, paragraph 10.
She has however informed that the additional compensation of rupees 1 lakh under the central scheme
Yes, Lordship, I have annexed the scheme.
is
also,
yet to
Lordship.
be received. Full stop. She has also submitted that
Annexed.
that expenses for medical treatment are also entitled to full stop. SS Roy, Learned State Council, prays for some time to obtain the up-to-date instructions. Para, list. Yes, well, list on 15th of October.
Lordship.
We're fixing date. These are
Lord.
important matters. 15th of October.
Deeply obliged.
May please, Your Lordship.
Is that Taravda file affidavit?
My lord, what happened, my lord, as per the instruction, my lord, the case is that, my lord, they have filed a title suit before the law court, my lord. They have got it, my lord, dismissed perhaps with cost also. My lord, thereafter, my lord, as per our instruction, my lord, they have filed a first appeal also. But that we could not locate, and as per our information, they dismissed in limine, but we could not locate the documents, my lord, and could not file the same, my lord. And now he has come, my lord, the son of the plaintiff, number 1, has come that to direct the DC to allot the land in his name. This is disputed land, my lord, of fishery, my lord, in which we are also fishing, they are also claiming they are also fishing, my lord. My lord, the court has dismissed the matter title suit matter with cost, perhaps, my lord. The appropriate forum is to approve the first appeal, my lord. So, my lord, how they can come to your lordship, my lord?
Yes. He has a point. If your civil litigation is pending in this court in the form of first appeal, where first appeal is in this court?
No, my lord, first in the court below, my lord. We could not locate it, my lord. We have come to know that from their persons that it is dismissed in limine, but we could not locate. We tried to make it copy and to file before the court, but could not, my lord, till now. My lord,
You at least file your affidavit. Let us have something on before this court so that we can pass appropriate orders. You have not filed affidavit.
my lord, not
Why?
file because but we
You
could not,
granted time on
we could not
16/6.
we could not obtain it, my lord. That's why, my lord,
Whatever is there, you have to file it.
because my lord,
Yes, what is what are the details of the first appeal?
My lord, actually, this matter mentioned by mistakenly, my lord. So my senior is now the out of station.
It can is it? By order.
Yesterday already mentioned, my lord, by mistakenly, my lord.
mention করেছিল
Out of police.
testing করানো
Not good police. Now, why have we mentioned her? PTO করেছে।
Mention is yesterday, my lord.
We allowed a mention today for, you said motion.
My lord, yesterday.
Huh? Admission. We don't allow admission on the next date. What did you do, mister? What happened?
Another.
What has happened?
Mentioned, my lord. So mistakenly, my lord, this matter mentioned.
You have marked motion here.
Yes, my lord.
You have given a number and you have marked motion. And you prayed for listing today for motion. This is a matter of 2024 and by strength of mention memo has come for admission. You have to pay heavy cost.
My lord, I am extremely sorry.
No,
my
no,
lord.
no, it's not a question of sorry. You cannot abuse the process of this court like this. You cannot. We'll not encourage this kind of practice. On good faith, we allow you because you said motion. We don't allow out of turn admission or orders unless it is urgent. And you had marked motion here. What is this kind of practice? Don't spoil the environment of this court like this. Don't degrade it. It's already degraded. You don't have any conscience. You just think that you have to come to the court, do anything you want. This matter has been listed on the strength of a mention memo. However, the learned counsel, Sri, your name?
R.I. Bhuya.
R.I. Bhuya has prayed for an adjournment, full stop. The mention memo has been carefully perused, which was filed yesterday, that is 15/9/2025, and it has been indicated in the said mention memo that the matter is for motion, and on that consideration, the mention was allowed for motion even on a hearing date, full stop. The matter, however, appears to be of 2024 and is at the admission stage, full stop. The practice adopted is wholly deprecated by this court, which not only is, not deprecated by the court, full stop. The matter accordingly stands adjourned. The learned counsel is imposed cost of ₹5,000 to be paid to the so-and-so. It is made clear that the cost is imposed on the counsel and not on the party.
Beloved, by your lordship's last order, lordship was pleased to direct both Mr. Kolita and Dhar to file an additional affidavit, my lord, by order dated 4/9/25.
Yes, correct.
My lord, the affidavit is ready, but because of this rain, my lord, there was some flooding in so many areas, they could not come, my lord. Let the matter come after the
Both
vacation.
are available.
In fact, my lord, when I came with early today, many of my colleagues have said, couldn't you find water in Bibura Road? I said, no, I got access. Because when I came, it wasn't there. Subsequently, it is already flooded.
So, yes, what do you do?
Yeah.
Additional affidavit will be filed by whom?
My lord, to clarify the position,
No,
my
who
lord,
will file?
there are two
There are
respondents.
two, who is going to file?
I have already filed. I am also replied to the waiting for certificate.
Okay, then file it.
Yes.
File it. Okay, when can we have?
Lordship can, after vacation, my lord.
We fix a date then?
Yes, my lord. Yes.
Okay. Heard Sri P.K. Roy Chaudhary, learned counsel for the petitioners. Also heard Sri S.S. Roy, learned state counsel. And Miss G. Hazarika, learned standing counsel, revenue department. Para? While Sri J. Kolita, learned counsel, has appeared for the respondent number 5 to 12, Sri K. Chaudhary, learned senior counsel, assisted by Sri A. Dhar, has submitted that he has also been entrusted to appear on behalf of the respondent number 5. And a separate affidavit has been filed. Para. This court on the last occasion, that is 4/9/2025, on noticing the aforesaid situation, had directed both Sri Kolita as well as Sri Dhar, learned counsel, to file additional affidavits to explain their contradictory positions. Full stop. The concerned learned counsel have submitted that though the affidavits are ready, due to some personal difficulties, due to the inclement weather condition, the affidavits could not be filed today.
Yeah.
And accordingly, they pray for some accommodation. Para. Accordingly, the consideration of this matter stands deferred they're deferred, and the matter is to be listed for admission on 22nd of October. By which time? 27th? 27th of October. By which time? The affidavit, maybe you are not be there. Tell us, date of your conviction.
29th?
29th.
Yes.
29th. By which time the affidavits may be filed.
My lord, interim order.
To be vacated.
No.
I don't mind vacating.
Before puja, not to be vacated.
Interim order passed earlier stands extended till the next date of listing.
Obliged.
My lordship, in respect of an additional affidavit, my lord, filed regarding justice service, my lord. In respect of respondent number 4, 6, 7, 8, 9, and 10. Lord, matter may be,
Affidavit filed.
yes, my lord, affidavit filed on 11th of September.
Heard Sri A.I. Mazumdar.
Yes, my lord.
Learned counsel for the petitioners who, by referring to the order dated 26/8/2025, has submitted that while notice was issued, liberty was granted for taking steps upon the respondent numbers 4 to 10, additionally by Dusty. He has submitted that such Dusty service has been, such steps for Dusty service have been taken, and in this regard, an affidavit has been filed on 11/9/2025. Perused the said affidavit, which has been filed by the petition number 3.
Yes.
Full stop. On perusal of the same, service upon the respondent numbers 6 to 11.
No, my lord, 4, 6, 7, 8, and 9, 10. Not 5, my lord.
4 to 10. 4 to
Not-
10. Okay.
Not
4 to
5.
10 we have said. Private respondents. Five also, you have said. 4 to 10, you have said.
4 to 10, no?
Yes.
I have.
And Dusty is for whom? No, 5, you did not take steps, right? What was the order? 4 to 10, private respondent. But we did not exclude 5 in the order. Are you appearing?
6 to 7.
Yes, are you appearing?
Yes, Lordship.
For whom?
I'm responding with 6 to 7, 10, Lordship.
6 to 10?
Yes, today I filed Bokolat, my Lordship.
6 to 10. Then what about 4 and 5?
4 and 5.
Not,
What about 5? 5 are you taking, Mr.?
No, I am actually.
No, Mr. Goswami?
Lordship.
5 is the secretary.
Considered. Oh, no.
Secretary of Gaon Panchayat.
The only standing council appears, Lordship.
Okay, secretary is a government servant.
Lordship.
Yes, yes.
Yes, Lordship.
কি লিখিল লাষ্টটো? Numbers 4, 6 to 10 is deemed to be complete. So far as respond number 5 is concerned, 3.
Standing. Doctor.
Oh, yes, sir. 3, as doctor had already accepted, as doctor, learned standing council, TNRD had already accepted notice. Full stop. Para. In fact, your name?
Yan Borua, on behalf of MD Chaudhary. Yan Borua.
Ann Borua.
Yes.
In fact, 3 Ann Borua Learned Council. You have also filed wakalatnama
Today file, Lord.
along with his colleagues. And Ann Borua has submitted that he, along with his colleagues, has entered appearance on behalf of respondent number 6 to 10.
10, Lord.
10 by filing wakalatnama today. Stop. He accordingly prays for and is granted 3 weeks' time to file affidavit in opposition. List after 3 weeks by reflecting the name of the learned counsel for the private respondents.
If possible, date may fix after vacation.
You have an interim order, don't you?
No interim order. Subject to.
Okay. Okay. A list on 27th of October.
Ablash.
Your Lordship, matter may be passed over for timing.
Wait, timing, what is the matter?
Lordship, this matter is for
for exemption was rejected by the department.
Exemption of,
Expansion.
Expansion of their industry. There is a notification, there are 2 clause 5A and 5B. They fall under 5A. So they are claiming benefit under section 5B.
he's playing for time being.
What's it?
After a while, we don't have much matter, maybe one more matter. Ask your senior to come after a while. Okay.
Wait, please, Your Lordship. Lordship, this matter is fixed for hearing today, Lordship.
Yes.
This matter relates to, if I may give a brief of the facts of the matter,
Yes,
Lordship.
please.
Yes, sir. Lordship, by virtue of an order dated
Who's
15.
for the other side?
NHI
Forest.
Forest is represented by the Standing Council, Karbi Anglong Autonomous Council. And
Is it?
NHIDCL Standing Council is also there, Lordship.
NHIDCL, you are there. Mr. Talukdar. Okay.
Lordship, by virtue of an, if I may start, Lordship.
Yes.
Yes, by virtue of an order dated 15/6/2011, land, 20 bighas of land was allotted to me by the Secretary of the Karbi Anglong Autonomous Council, Lordship. Lordship, those documents starts from page 37. Pursuant thereto, the patta of the land is also given to me. And at present, I am in continuous possession of that land, Lordship. Lordship, Annexure 1 series, the page 37 it starts. The allotment orders is at page 37. And thereafter, Your Lordship will find in a series, my periodic patra is also there. The Chitra and all Jamabandi.
Okay, now what is the problem?
Now, Lordship, what happened in the year 2020, the Ministry of National Road Transport and National Highways engaged NHIDCL for construction of a national highway number 29 from Doboka to Lahorijan, Lordship. And in that matter, and for that, they prepared a land acquisition plan, Lordship. If Your Lordship for a moment comes to land acquisition plan, that Your Lordship will find at page 59.
59.
Yes, that's my Annexure 2 series, page 59. So NHIDCL appointed a consultancy service who prepared this detailed project report, Lordship. So if Your Lordship sees the detailed project report, the yellow line going through the middle of the page is the
land to be acquired for the construction of National Highway 29. So if your lordship comes to the right hand side of the page, 415 near Mohendijua Forest, Mohendijua NC area.
Yes.
Yes, that is DAG number 415 and periodic patta number 81 is my landlordship.
Yes.
So the land acquisition plan categorically showed that the highway will go through my land. So what happened in the meantime, thereafter this LAP was prepared, and next page is the land schedule document also. The land schedule document also at serial number 20, my land is mentioned, lordship. My land of DAG number 415 and periodic patta number 81. Thereafter, your lordship, if your lordship comes to page 61, annexure 3, an undated map has been prepared by the respondent number 4 and 5. Page 61, lordship.
Yes.
So page 61, an undated map was prepared by the respondent number 4 and 5. At top, your lordship will find the village remains the same, Mohendijua NC, that is my village. So if your lordship sees the map and compares it with the page 59, lordship, what they have done, without giving me any notice or nothing of that sort, the land that was in my name from through which the national highway was to pass, that was substituted by some unknown DAG numbers, lordship. Those are 693, 694, 695 and 696. So this map, your lordship will see there is no date, nothing. So this substituted my land, lordship. So thereafter, what happened on the strength of this undated sketch map, a notification under 3A of the National Highways Act 1956 was issued, dated 14/12/2021. Annexure 4, it starts from page 62.
Yes.
Yes, in this notification, lordship, if your lordship turns to page 65, those unknown DAG numbers that were substituted in my land,
yes,
under that undated sketch map of village Mohendijua NC, page 61, were shown to be for acquisition, and it was shown as Mohendijua block number 4. Here we are concerned with lordship 693, 694, 695 and 696. So when I came to know about this 3A notification, my land was left out and some unknown DAG numbers were there in the 3A notification. I immediately preferred a representation. That your lordship will find it starts from page 67. I preferred a representation to the Ministry of Road Transport and National Highways. So intimating them that due to some mistake, unknown DAG numbers have been shown against my plot of land covered by DAG number 415 and patta number 81. So thereafter, what happened at 67? This my complaint was thereafter forwarded to the General Manager of NHI DCL, lordship, who this 5 and 6 series your lordship will find, who thereafter forwarded my complaint to the Joint Secretary cum Competent Authority for Land Acquisition and also to the Principal Secretary of the Karbi Anglong Autonomous Council. So in this regard, your lordship, the General Manager continuously sent his notifications to asking the Karbi Anglong Autonomous Council to do the needful, but till date nothing was done. So ultimately, if your lordship comes to page 72, on page 72 is another reminder, lordship, if I may read that. Page 72. This was sent to the Joint Secretary, who is respondent number 4 in this writ petition. Request to respond and dispose the matter from your end regarding public grievance number so-and-so raised by Mr. Manoj Hasnu. This unknown DAG number so-and-so has been issued against my plot prior to make immediate and strict action for correction of my land bearing DAG number so-and-so, as I am the original plot owner. So thereafter, this was again forwarded to the respondent number 4, but he didn't pass any orders, gentlemen. So being left with no other option, what happened, lordship? Thereafter, a 3D notification came up. In the 3D notification, the earlier DAG number 693, 694, the 3D notification is dated 30 March 2022. Your lordship, it starts from page 73. So in the 3D notification, the unknown DAG numbers were left out, lordship. The unknown DAG numbers that were shown against my plot of land was left out because My complaint regarding the correction of the same was still pending against the concerned authorities. So that the 3D is gone. So thereafter, Lordship, what we did, since the concerned authorities didn't do the necessary correction, I preferred an initial writ petition before this honorable court. The writ petition came up and it was numbered as 4191 of 2022. Your Lordship will find the order at Annexure 8. So that writ petition was disposed of at the stage of motion, Lordship. So that this honorable court granted me liberty to file a representation within a period of 2 weeks. The Lordship will find the operative part is at page 81 in view at the bottom. If I may read the operative part, Lordship.
Just a minute.
Yes, page 81. Page 81, Lordship. The second,
Yes.
in view of the above, has your Lordship got that?
Yes.
In view of the above and as agreed to by the parties, this writ petition is being disposed of at the stage of motion hearing by granting 2 weeks time to the petitioner to submit a detailed representation along with a certified copy of this order before the respondent number 3. That is the respondent number 4 over here. If such a representation is submitted within the time period provided by this court, the same be looked into and be disposed of by a speaking order after carrying out proper spot verification and upon due consultation of the relevant revenue records within a further period of 6 weeks. Until the above exercise is completed, no payment shall be made in respect of the plot of land claimed by the writ petitioner. And with that, those observations, the writ petition was disposed. So thereafter, since no order, we preferred a representation that your Lordship will find it page 83, Annexure 9. We preferred a representation within 2 weeks of that earlier order. But since the respondent authorities didn't pass the speaking order within a period of 6 weeks, we preferred a contempt petition. While that contempt petition was pending, Lordship, the respondent number 4 passed his speaking order, Lordship. The speaking order, this is very important, Lordship, may come to page 86, 21/6/2023.
86.
Yes, page 86, Annexure 10, Lordship. Annexure 10, yes. Lordship, in this speaking order, Lordship, if I may read the order.
Yes, please.
Lordship, I am starting from para 2nd because the first paragraph notes about the High Court's order and the directions. In pursuance of the order passed by the Honorable High Court, the petitioner Sri Manoj Hasnu submitted a representation number on 30/6/2022, enclosing a copy of periodic patta number 81 of DAG number 415 of Village Mohendijua NC, and notification dated 14/12/2021 and 33/2022 issued by the MORT, representation dated 23/3/2022 and the order passed by the Honorable Court. On receipt of the representation, so and so, case number 12 of 22 was registered and notice was issued to the petitioner and Assistant Settlement Officer, Defu Revenue Circle on 19/10/2022. The Assistant Settlement Officer submitted a report stating that as per the revenue record, the name of the petitioner, Sri Manoj Hasnu, was mutated in the revenue record on 18/7/2011. The Assistant Settlement Officer, Defu Revenue Circle, was also asked to produce the relevant record of Chitta and Jamapandi. The original record was produced before the undersigned, and it appears that the land measuring 20 bigha covered by DAG number 415 of Village Mohendijua NC was mutated in the name of Manoj Hasnu on 18/7/2011 in pursuance to the allotment order number dated 15/6/2011. Subsequently, Sri Manoj Hasnu has parted part of his land to Sri Torun Rongpi and Sri Gita Terongpi by way of gift. This gift is also I have annexed in Annexure 1 series. Total land of 2 bighas, 2 kothas have been gifted by me out of 20 bighas, Lordship. So now your Lordship will come to page 87.
Yes.
The DAG number 415 and periodic patta 81 as per the revenue records, as per the order passed by the correspondent authorities, it is in my name, Lordship. So now their findings regarding the substituted DAG numbers, Lordship. In pursuance, Lordship may come to the 3rd paragraph of page 87.
21/6 order.
Yes, 21/6 orders, page 87. Lordship may come in pursuance of the direction, Lordship. 3rd para.
Yes.
In pursuance of the direction issued by the undersigned, joint verification of the land covered by DAG number 497 of village Mohenjo NC, and DAG number, these DAG numbers are relevant in this case, 693, 694, 695, 696, 698 and 699 of village Mohenjo block number 4 was carried out by the officials of Revenue and Forest Department of KSE on 1/6/2023, and the joint verification report was submitted to the undersigned on 2/6/2023. In the report, it has been stated that DAG number 693, 694, 695, 696, 698 and 699 of village Mohenjo block number 4 falls under Jamuna DCR. Jamuna, in the revenue records, above mentioned DAG numbers are recorded as forest land. And thereafter, they say that my land is not required for construction of the National Highway Lordship. And they have given another finding in section 3D3 that 3D notification is to be issued within a period of 1 year. And since no 3D notification was issued in case of this unknown DAG number 693, 94, 95 and 96, so that also ceased to exist. So that was also not part of the land acquisition process, Lordship. So that your Lordship will find the final findings at page 89, it ends. So after seeing this report and noticing that the same plot of land that is in my possession, Lordship, they are trying to show it as in my possession also and as also forest land, I again preferred a writ petition, Lordship. A representation was again preferred by me. That representation your Lordship will find at page 93. To do the needful by correcting, by showing as to where my plot of land is, whether that the forest land and my plot of land are same or not.
Which
So
representation at page?
that's 93, Lordship, annexure 12. Therein I have given all the details about the earlier case and all. So this representation was kept pending by the concerned authorities. So since there was no action taken, we again approached this honorable court. This
Representation was to the revenue department.
Yes, Revenue Department and Lordship, we have given copies to your Lordship will find at page 97. We have given copies to the Chief Executive Member KSE and other respondents, other persons have been also copies have been given. So Lordship, since no action was taken on our second representation for clarification, we filed another writ petition, Lordship. That writ petition was numbered as 6620 of 2023. This writ petition was disposed of by this honorable court on 12/2/2024. I'll take your Lordship directly to the operative part of that order. Lordship may come to page 101. 101 para 6. Lordship got it?
Yes.
If I may read from para 6, Lordship.
Yes.
From the contents of the speaking order dated 21/6/2023 that I just showed to your Lordship, it is noted that on submission of representation by the petitioner, a case number 12 of 2022 was registered and notices were issued to the petitioner and the Assistant Settlement Officer, Diffuse Revenue Circle. It further transpires that the Assistant Settlement Officer, Diffuse Revenue Circle, submitted a report during the course of the said proceeding. The Joint Secretary, Revenue, Karbi Anglong Autonomous Council, after perusal of the said inquiry report and other revenue records, has observed that the plot of land measuring 20 bighas covered by DAG number 415 of village Mohenjo NC was mutated in the name of the petitioner on 18/7/2011 in pursuance of the allotment order dated 15/6/2011. In respect of the plots of land covered by DAG number 693, 694, 695 and 696, the said authority had observed that those plots of land are located at village Mohenjo block number 4. Such observation was made on the basis of a joint verification report submitted by the officials of the Revenue Department and the Forest Department of the KSE before him on 2/6/2023. It has been recorded in the speaking order dated that the plots of land covered by DAG number 693, 694, 695 and 696 of village Mohenjo block number 4 fall within Jamuna District Council Reserve Forest, and as per the revenue records, those DAG numbers are recorded as forest land. And 2, the plot of land covered by DAG number 4115 of village Mohenjo is not included in the land acquisition plan prepared jointly by the NHIDCL Revenue Department, KSE and the DPR consultant of the NHIDCL. From the speaking order, it is further reflected that as on date, neither the plots of land covered by DAG number 693, 94, 95, 96 situated village Mohenjo block number 4, nor the plot of land covered by DAG number 4155 of village Mohenjo NC is under any land acquisition process for the National Highway project. So now your lordship may come to next page 8, the directions issued by this honorable court, the last case. Page 103, para 8. This court is of the considered view that the Joint Secretary Revenue, KAC, who is also the competent authority, lordship, respondent number 4, is in best position to examine and decide the said issue on the basis of a fact-finding inquiry conducted on the basis of the revenue records available with the respondent KAC and the documents to be submitted by the petitioner in course of such an inquiry. In such view of the matter, this court deems it appropriate to dispose of the writ petition, granting liberty to the petitioner to submit a detailed representation along with all supporting documents available at his disposal before the Joint Secretary Revenue KAC within a period of 15 days from today, and after such representation is submitted, the Joint Secretary Revenue KAC shall examine the representation and issues firstly whether the plots of land covered by DAG number 693, 694, 695 and 696 situated at Mohandijua block number 4, and number 2, the plot of land covered by DAG number 415 and periodic patta number 81 located at village Mohandijua MC are one or different, and secondly whether those two plots of land are located at different places or not. In the course of such inquiry, the petitioner should be afforded personal hearing and liberty to file all supporting documents available at his disposal on the subject matter. The petitioner, this is very important, the petitioner shall also be given the liberty to peruse the original revenue records in presence of officials of Karbi Anglong Autonomous Council. It is further observed that the fact-finding inquiry shall be completed by passing a speaking order as expeditiously as possible, preferably within a period of 45 days from the date of submission of the representation. In order to facilitate expeditious consideration of such representation, the petitioner shall appear before the office of the Joint Secretary Revenue KAC at 10:30 AM on 18/3/2024. If the petitioner is found himself aggrieved by the speaking order, the petitioner will be at liberty to avail appropriate remedy as permissible under the law. So this the earlier writ petition was again disposed of, wherein the respondent authorities were directed to give me a personal hearing, show me the relevant revenue records, and then this honorable court also fixed a date. On that date, lordship, I went to that office, but unfortunately the respondent number 4 was not present. So no revenue records was shown to me and no order was passed, lordship. So thereafter, what happened, lordship? After this order, that again the representation as directed by this honorable court on annexure 14, page 105, I have given this another representation, lordship. So this representation was again given to the respondent number 4, lordship, and all the necessary documents I have given along with the representation, lordship. So thereafter, again, there was no orders passed, no hearing conducted by the respondent authorities, lordship, no revenue records were shown to us. So we preferred another contempt case. So again, during the pendency of the second contempt case, lordship may come to page 109. The second speaking order came to be passed, dated 3/6/2024. Here, the gist of the speaking order is that both the plots of land, the unknown DAG numbers, page 109, lordship. So the gist of the speaking order is that the unknown DAG numbers 693, 694, 95 and 96 and my plot of land are situated at different places, lordship. And they have accordingly said that my plot of land is not required for construction of national highway. And so that this was the speaking order passed. So thereafter, nothing happened, lordship. So what your lordship will see, both the lands, the unknown DAG numbers and my plot of land was not, as per their speaking order, was not required for construction of national highway. So in the meantime, lordship, what happened? They started constructing the highway on my plot of land, lordship, without there being any notification under 3A, 3D. So when I came to know that the highway has been constructed on my plot of land, DAG number 415 and periodic patta 81, I again immediately shot off a representation to the respondent number 4. Your lordship will find it 112. In this representation, I have given all the details of the earlier cases to the respondent number 4, and thereafter my land details also, and thereafter requested the respondent number 4 to stop the construction of the national highway on my plot of land, as the same has not been till date acquired as per law. So thereafter, again, there was no action on part of the respondent authorities. I have annexed the photographs also. Your lordship will find at page 116. So there was no action on part of the respondent authorities and the construction of the highway went on. So now thereafter I preferred this third writ petition, Lordship, before that is pending before your Lordship. So what happened, Lordship? Why I am before your Lordship is that the land acquisition plan at page 59 that I have shown to your Lordship, that is categorically prepared. And there my plot of lands have been shown to be needed for acquisition of land, for construction of national highway. But an undated sketch map before making which there was no notice issued to me. They substituted my land and showed it as unknown DUG number. So thereafter, the rest of the documents I have shown to your
Now,
DPSS.
what is the relief you are praying for?
Lordship, I am not against taking off my land. As per Article 300A, I have to be given the fair compensation, Lordship. So I want compensation to be paid, Lordship. So what?
Mr. Chutia, is it a matter of fact that his lands
My lord,
have been acquired?
my lord, fact, it is not a fact, my lord. The land of the petitioner is situated in different place. We have issued, as per the direction of lordship, and look into the order dated, my lord, 28/8/2024 of this petition. Order dated 28/8/2024.
28/8/2024.
Second paragraph 4, my lord. The instant petition is the third round of litigation. The grievance of the petitioner is specific that he has a plot of land and measuring so and so bigger than so and so, order number so and so. It is the case of the petitioner that the respondent number 6 has initiated construction over the land of the petitioner without carrying out any acquisition proceeding. On the earlier occasion, there has been a direction issued by this court for making spot verification, but the spot verification which was made on 3/6/2024 does not show that there was any spot verification to the effect where the petitioner land is situated, there is any construction.
Paragraph 8.
My lord, in view of the submission, this court shall consider an interim prayer on so and so. In the meantime, the Cabinet Council, more per respondent, is right to carry out the demarcation of the land of the petitioner and submit a report as to whether the land of the petitioner has, we have submitted a report, my lord.
A demarcation process.
My
If
lord.
I may complete, then
No, just we will come to you.
My lord. Then, my lord, we have issued.
What do you find in the what have
My
you
lord, we
stated
have
in the
annexed in the
report?
affidavit, my lord, in the presence of the petitioner, my lord. That is, my lord, annexer to page 129.
Joint verification.
Joint verification,
7
my
times.
lord. Sri Monu Sasno has raised the claim that the NSATCL has constructed a 4-lane road of so and so without acquisition of his land covered by DUG number so and so. The joint verification of the land in respect of his claim was carried out on 7/9/2024 in the presence of General Manager NSATCL, Secretary Revenue, Assistant Conservator Forest GE NSATCL, Kalakam Joint Secretary, Assistant Revenue Officer so and so so and so. The proposed map of Jamuna DCRF GTS land notification dated so and so, sketch map and Sita village of so and so were consulted. In the spot verification, the claimant Monu Sasno was also present. On spot verification and after consultation of the records, it is clear that the construction of Manja bypass of NS so and so starts from boundary of the village Ekorani block number 1 and the particular land which was claimed by Monu Sasno as his own on which the 4-lane of NS2 is constructed are in fact within the Jamuna DCRF. There were no inhabitants in the area claimed by the petitioner as both the sides of the roads are covered by the forest. The map prepared during the joint verification is enclosed as part of the records. Conclusion, on spot verification, it is found that the land covered by so and so is not required to be acquired for construction of NS 29. The land covered by DUG number so and so is not under the alignment of the road construction for NS 29. Then, my lord, we have prepared the, my lord, that sketch map and the photograph also, my lord, in which the, my lord, petitioner was present, my lord.
This part, lot of land covered by 415,
My lord.
DUG number 415, PP number 81,
My lord.
is not required for acquisition
My
because
lord.
it is not within the alignment.
My lord.
And
the
this
land,
is the land which you are claiming to
yes,
have been
my
acquired.
lord. And we have issued demarcation notice to the petitioner to be present
as per the direction of the Honorable Court, but the petitioner was absent at the time of demarcation of his own plot of land. As it is under the Mohendijua NC, non-cadastral area, 20 bighas of land was allotted in a non-cadastral area. So the petitioner was asked as per direction of the court to be present at the time of demarcation, but the petitioner failed to appear before the court. And the land acquisition plan is required to be prepared jointly by the NSADCL and my lord, NSADCL. And there are land acquisition plan which was submitted of petitioner is an unsigned document, my lord. How he can get it, my lord, is a different thing, my lord. But the Annexure 5/132 is the land acquisition plan that is with the signature of the person is there, my lord. This is the land acquisition plan. And the land acquisition plan, which is in draft stage, my lord, at that time he obtained it and submitted it, but how he get it, my lord, that has not been disclosed.
Mr. Chutia, we may not go
In
into,
effects, my lord.
we may not go into which is the correct map, which is
My
not
lord,
the
my lord.
uncertified map.
My lord.
But the conclusion in the joint verification is that the land under DAG number 415 is not
Not
required.
required, my lord.
Then if it is not required,
My lord.
then why is the petitioner making an allegation that his land is being
My lord,
utilized?
it is, my lord, on the basis of presumption that this particular, that is a NC area, my lord. If petitioner should, we have filed, we have submitted the application in the order, we have
So that
specific.
come to a determination whether it is your land or since.
Yes,
they
Lordship,
have
my
written
lord,
an
that's
affidavit.
Yes,
My lord.
yes, what happened, Lordship? First, the joint verification report, I didn't sign in it because it was not.
No. Even if you assume that
Yes.
this verification report
Yes,
is
why,
wrong,
Lordship? Oh,
let
sorry,
us
sorry,
assume
sorry, yes.
that this verification report is wrong.
Hmm.
But it has come up as their stand, as their defense. Now, how do you counter this in a
Yes,
legal
Lordship,
proceeding?
just Lordship may come to my, first I'll show your Lordship. They say that the Karbi Anglong Autonomous Council, along with NHIDCL, has to prepare the land acquisition plan. That is absolutely false. And he has himself stated in paragraph 5 of his affidavit.
No, let us not go. Let us not
Okay,
go
Lordship,
into all those.
okay, I'll not be.
Now,
Lordship, they say-
what is the land which is the subject matter?
Yes, Lordship, the
It is
415.
415.
Yes, Lordship.
Now, they have said that 415 is not even in the alignment.
They say they have constructed in inside a reserve forest. So
We are not on that.
Yes.
They have said that 415, that number is not even in the alignment. So there is no question of acquiring this land.
Yes, I'll come to that. Lordship, just kindly give me some time. I'll show you all. They say that joint verification report says that the plot of land I am claiming is inside Jamuna DCRF. And that is not at the actual plot of land. And the highway has been constructed within the Jamuna DCRF. So in this regard, we filed an RTI. RTI, your Lordship will find in my affidavit in reply, Lordship.
Yes.
This RTI was prepared to the respondent number 4, who is the divisional forest officer of that block, Karbi Anglong. Page 150, Lordship, will come. 150. First question, 1, 4, and 5 questions I have asked are very relevant for this case, Lordship. First question, have you got, Lordship, got it?
Just a minute,
Yes.
please.
Page 150 of my affidavit in reply, Lordship. Affidavit in reply dated 15th of May 2025.
17.
Lordship got paid.
You want to come to 150?
Yes, 150 is my RTI queries, Lordship. Thereafter, I'll show the answers also, the reply of the concerned authority.
Yes, please.
So 1, 4, and 5 questions are very important, Lordship.
Yes.
Are DAG number 693, 694, 695, 696 parts of forest land under Jamuna DCRF? The substituted DAG numbers. They have stated categorically in their speaking order that the revenue records show these are forest lands. Second is whether till date any forest land under Jamuna DCRF has been acquired for construction of National Highway 29. If any, and number 5 is if any forest land under Jamuna DCRF has been acquired for construction of national, then kindly furnish the land details. This was given to the DFO of Karbi Anglong office. Now the answers your Lordship will find at page 151. It's same, it's on their department person only, Karbi Anglong. Reply for question number 1. The specified DAG numbers 693, 694, 695 and 696 are not forest land under Jamuna DCRF, as the area covering the construction zone from Chainat so-and-so to Chainat so-and-so as per LAP is beyond the Jamuna DCRF. Next question, reply to question number 4 and 5 I will show whether any land was acquired, I asked. of Jamuna DCR, the forest land. They say categorically no. Forest clearance proposal is at the first stage. Now I will come to the fact that Lordship is very much aware, and I have a Supreme Court judgment to supplement it also. Before any forest land is diverted, forest clearance has to be taken, Lordship. And forest clearance has to be
See,
taken
Mr.
before...
Chaudhary, we are not, that is not the issue before us.
Yeah.
Issue is whether you are entitled to compensation qua any land of yours being acquired. They have come categorically, no land of yours have been acquired.
But they are saying that they have constructed the highway. My land has been
No,
acquired.
whether they have constructed the forest or otherwise, that is not your concern. You are for your own rights,
And
trying to espouse your own
yes,
rights.
Lordship, what I will say...
If you can make out a case, yes, your land has been acquired or your land has been utilized without an acquisition proceeding, we'll direct them. But joint report says
Lordship,
something else.
this one also you must see that, Lordship, the respondent number 7 at page 153,
Yes.
he issued notices to the other, the joint secretary and all,
Yes.
to conduct a joint verification, so that he can file an affidavit, as this honorable court directed the DFO also to file an
Now,
affidavit.
how do you counter? It's a word of mouth. You have said it's acquired, it's utilized. You have said it's not utilized. 415 is outside the purview of acquisition.
Lordship, why I am saying is that I have no other option. They have,
And what do you
and
say?
the original, Lordship, one more prayer.
do you
Lordship.
say?
NICDCL will say, my lord, that regarding the land acquisition plan, NICDCL engaged by the consultancy firm. They are preparing the land acquisition plan, not by us, my lord. They are with our
Which land?
consultancy.
Which land has been acquired?
Lordship,
Mr.
land
Damodar?
acquisition plan is to be prepared by the competent authority, then it is to be submitted before the ministry, Lordship, then
Yes.
gazette notification is published. And in this case, Lordship, acquiring agency is the Karbi Anglong authority.
Yes.
So, Lordship, NHA is nothing to say, Lordship, because we are
No,
repeatedly.
the records which have been transmitted to you,
Yes.
does it cover amongst the acquired land? Does it cover 415 DAG number?
Lordship, may kindly see the records. It is will be in the
Record is not available. with me.
approved records, Lordship.
Does it cover 415? That will end the.
And Lordship, that
Yes,
LAP that
yes.
I have shown, that
Lordship,
59,
gazette
let him
notification
deny it,
already
Lordship.
published, Lordship,
Let us see.
as per land acquisition plan, Lordship.
Let us see the gazette.
And 3A3D notification, no forest land has been mentioned over there. So where have they constructed the highway, Lordship? That is very important.
Gazette
That is
notification is, Lordship, page 62 is, Lordship, one, Lordship, that is 3A. And there.
the approved revenue record, land acquisition proceedings will be with the NHIDCL, approved from the Ministry of Road Transport and Nation. Those records need to be produced, Lordship.
Subsequent gazette notification after, my lord, a joint verification report, the Ministry of Home Affairs, Minister of Road Transport Highway issued a gazette notification, my lord, regarding 3A, my lord, and 3D, my lord, after the joint verification. That is on 3rd January 2025, my
I
lord.
have seen there is no forest land mentioned in that notification.
That is, my lord, government land, my lord. The petitioner, the claim of the petitioner, that is in respect of the government land, and that is the agricultural land, road is there, my lord, that is the part. And the land claimed by the petitioner is not acquired by that.
No, this gazette notification, does it refer to any particular plot of land?
My lord, my lord.
Where is it?
My lord, lordship can look into, my lord, district state of Assam, survey plot number. There is a ANC, my lord, non-cadastral land, my lord. Type of land, government land. Nature of the land, agriculture road, area so and so, 0.2325
No,
after.
the land has not been, where is?
This is Ekorani
The
NC, Lordship.
land has not been identified by this. Can we come to page, let us try to understand, page 62. Page 62, the initial notification,
My
under
lord,
3A,
my lord,
at 14th of December 2021.
my lord.
Now, so far as this
My lord,
particular,
that part of land, my lord, is for lordship land, section 3D3. Under section
no,
3D3,
just a minute, come to 65, please.
my lord, 65, my lord. There is a 3A notification, my lord, 3 capital A notification.
No,
If
can
the-
come to page 65, please.
65, my lord, these are the 693, 694, these are the, my lord, though it is shown as a private land, as per the, my lord, settlement record, it is a, my lord, forest land, as per the settlement record, my lord. So, my lord, it was wrongly published, so 3D notification was not published, and it is automatically lapsed, my lord, after 1 year, my lord. So there is no 3D notification in respect of this land. That is under section 3D3 of the National Highway Act. After publication of notification under section 3A of the National Highway Act, if no notification under section 3D1 has been published, it is automatically ceased, my lord. Lordship will look to section 3D, my lord. We are under section 3D3, where in respect of any land, a notification has been published under subsection 1 of section 3A for its acquisition, but no declaration under subsection 1 has been published within a period of 1 year from the date of publication of that notification, the said notification shall cease to have any effect. So, my lord, this notification, my lord, the claim of the petitioner on the basis of the 3A notification, that notification only in respect of Mohenjo block number 4 has ceased to be effect, my lord. So there is no notification in respect of those particular dark, my lord. And the petitioner, his claim is only that instead of his claim, these dark numbers were reflected, my lord.
And lots of page 61 is the undated sketch map. They have stated Mohenjo NC and the dark numbers are 693. And this map has been prepared by the respondent number 4. His initials are there. That is why I'm insisting, Lordship, the approved land acquisition plan that is with the NHIDCL should be perused by the Honorable Court, Lordship.
We have annexed it, my lord. In our affidavit, the approved land acquisition plan with the signature, we have annexed it as page 132, my lord.
Lordship,
And this is the approved my lord, land acquisition plan, and on that basis, my lord, 3 and 3D notification was published.
there is no 3 and 3D notification regarding forest land, Lordship. Let him show from the record that there is a 3A, 3D notification. They have constructed the highway over Jamuna DCRA. And this
Mr. Chaudhary, we will not go into that issue.
No, I'm not, Lordship. This
We
land
are only trying to examine whether you would be entitled to any
Yes,
compensation.
Lordship, that is why I'm saying this land acquisition plan, my friend has just showed to your Lordship. Lordship, I have annexed the same. That is of July 2020. Lordship, here the last part of the map is missing, Lordship. And I have annexed the same notification in page 154 of my affidavit in reply. There also my land is shown. Let the NHIDCL deny. This is prepared by the NHIDCL.
Which part is missing here?
Lordship may come to page 154 and compare it with 132. 154 of my reply. That is the LAP. And 154 of my page, Annexure E, and there page 132 of his affidavit in opposition, Lordship.
Yes.
Lordship may see the last part. Rongbong Pothar, your Lordship has seen. And kindly see the map I have annexed. This is the map given to me by the General Manager of NHIDCL, Lordship, when I lodged the complaint on 2022. And I have categorically stated in my reply all these facts, Lordship. So they have made the last part of the land acquisition plan disappear and produce it before your Lordship. See, dark number 415 is categorically mentioned yellow column for land acquisition plan. Lordship, if there would have been something fishy is seriously going on, Lordship, otherwise I will not file 3 writ petitions before your Lordship. And regarding demarcation as directed by this Honorable Court, 2 lot mandals came, I was present. They asked me to accompany them to the nearby forest land, Lordship, so that they can demarcate the land over there. I have categorically stated in
Yes, what do you say about 154, Mr. Chutia?
Yes, NHIDCL has to clarify, Lordship.
My Lordship will look into the 154.
Yes.
Whether any signature is there.
No, not on the signature.
Nothing, my lord. It is not, my lord. It is not notified. It is not, my lord. LAP, my lord.
Just compare it with 132. 132, the yellow portion,
my lord,
stops abruptly. So far the acquisition is concerned.
This highway goes on to Lahorijan, Lordship.
And he has projected that beyond this small path, it goes beyond, and 415 is also affected.
My lord.
And another case is pending, 447,
Just-
your lordship will see, that case is also pending before this honorable court. That person has also been shown, his land is also been shown as forest landlord. So that is why I'm praying, lordship, the original records, let the NHIDCL, the approved records of the mort.
My lord. Approved,
You
my lord.
get the approval.
And the land acquisition plan, lordship.
Lordship, there is no seal and signature,
My lord.
that's doing lordship.
No signature, how he can be, my lord.
No, that we have noted,
Hmm.
but we just want to know.
Original by lord, which they have
original,
approved. my
Because
lord. You can
after,
say.
at 132, after the yellow portion,
Where did the highway go, lordship?
My lord.
is there
The
any
other-
further acquisition?
Other acquisition part is there, my lord.
Yes.
So it is continuing.
No,
process, my lord.
see, acquisition would be there, but we are concerned only if the
Second part,
land
my
of
lord.
the petitioner is
My
acquired.
lord, it is not at our record, my lord. In the second part, my lord, it is, my lord, village record. And next, my lord, we can produce it also, my lord. They can also produce it, my lord. If
But
it is a continuous land, my lord.
Yes, yes.
It can be, my lord.
See, Mr. Chutia, you need not be, there should not be any misunderstanding
My
that
lord.
this uncertified document would be taken note of this by this court. We'll go by, but this has created some doubt
My lord.
regarding the aspect as
My
to
lord.
whether there has been further
lord.
acquisition,
My lord.
which includes
My lord.
415. That is the only
My lord,
question.
land acquisition plan is prepared by the consultancy firm. They may get it from the consultancy firm before approval, my lord, or before when
But
it is
Mr.
prepared.
Talukdar says that
He will
it's
say.
it is you.
My lord, then on a consultancy firm.
Who is the consultancy firm?
Buoyant solution,
And
lordship.
solution, lordship.
The approved documents of the mort should be called for,
My
because the
lord,
land
my
acquisition
lord.
plan is approved by the mort.
My lord.
The
It can be, my
autonomous
lord.
council
NHIDCL,
will
my
again
lord.
produce this forged
MP
document.
Chaudhary.
Hmm.
Heard MP Chaudhary, Lennox Council. For the petition, I also heard Sri J. Chutia, Lennox Standing Council, CEAC, as well as Sri R.K. Talukdar, Lennox Standing Council, NHIDCL. Para? While the dispute, if perhaps dispute appears to be one which is factual in nature, Sri Chaudhary has submitted that from the materials obtained by him, including a map given to the petitioner, furnished to the petitioner by the NHADCL,
Yes, Lord.
in the acquisition, in the land acquired for the construction of the road in question, there is mention of land under DAG number 415.
Yes, Lord.
Which is the land in question, full stop. This court has, however, noted that in the map furnished by the KAC in its affidavit filed on 22/4/2025, the same does not contain the aspect as to whether 415 whether land under DAG number 415 is involved. Full stop. Sri Chutia, the Land Standing Council, has, however, submitted that the map produced by the petitioner does not bear any seal or signature, whereas the map enclosed in the affidavit of the council, CIL, is an authentic one. Full stop. Para. Be that as it may. To resolve the dispute, let the original records containing the map be produced. Who will produce?
Approved by the mort, lordship. The LAP approved by the mort.
The records is required to include the map approved by the ministry. Full stop. Sri Talukdar, the Land Standing Council, NHIDCL, accordingly prays for and is granted 2 weeks time to produce the said records. Para, we give a date then.
After vacations, lordship?
List immediately after the vacations.
Lordship will fix a date?
Yes, Mr. Talukdar, get the, should we fix a date?
Lordship, is 28
Tuesday or Thursday?
28 October.
28 October, lordship.
List on
28 October.
28/10.
Highly obliged, Lordship.
If the settlement records are required to be produced, I can also, it can be produced.
Whoever, you can also get the record.
Yeah, please, Your Lordship. Lordship, this is a matter relating to central excise exemption. Lordship, what happens, Lordship, there was a.
Lordship. No, he is a Lex in another court, Lordship.
Lordship, I'll start, Lordship. You will come. I'll start. I'm really sorry, Lordship. I became a bit late. Waterlogging was
We'll
there.
have it at 2 o'clock then. Ask your senior to come at 2 o'clock.
Lordship.
Okay. I'll wait a minute. At 2 o'clock.
Yes. Highly obliged.
May please, Your Lordship. Lordship, inadvertently, I forgot to carry the file. Lordship, I forgot to carry the file, my lord.
You forgot to carry the file.
My lord. My lord,
You did
fortunately,
not forget to come to the court. You should have forgotten to come to the
I'm
court.
so sorry, my lord. Fortunately, my colleague is also, my lord, not here for the bank.
Yes, Mitra, learned counsel for the petitioner. Praise for little accommodation. Full stop. The respondent bank is, however, not represented. Para. In view of the above equation, the matter is adjourned to be listed. Listed after the, immediately after the, listed after the autumn vacations. You are for whom, madam?
Madam, I am from respondent number 9 and 10.
Who's 9 and 10?
I'm N. Kalita on behalf of MSK Fukon.
CGC. Respondent numbers 9 and 10 are however represented by Miss N. Kolita, learned counsel, appearing N. Kolita, learned counsel, appear in instruction of Miss K. Fukan, learned CGC. Okay. Yes, madam, anything?
Lordship, I'm very sorry to be bothering you with this. May I mention item 1 and 2? It came up in the morning. The petitioner's counsel was not there. Dr. Saraf was not there. It's kept on Thursday. It absolutely slipped my mind. I have some personal difficulty on Thursday morning. Even afternoon is okay, or Tuesday. I've spoken to both Mr.
Next
Tambuli.
Tuesday will not be possible. Next Tuesday, next week will not be possible.
Then Lordship, accommodate me the first half.
We'll try, we cannot say, we'll try to, but in that case, it might go after the vacation. Let's see, we'll try to accommodate you.
Oblige, Lord.
We'll come at 2 o'clock for your matter. Let this is Mr. Kyle also be there.
Much obliged.
It is a very urgent matter. Well, we have filed a case on 8-9.
Motion?
Yes, motion.
When do you want?
Tomorrow, my lord.
Tomorrow.
Because on 8-9 we have filed, not yet.
What is
listed.
the urgency?
Urgency means, my lord, I am a panchayat and my ghats have been allotted by the BDO to 2 private persons. So it will be precedent.
So Friday will be too late or what? Friday?
Let it be day after tomorrow.
Okay, Thursday then.
Obliged to.
May I please, Your Lordship? Lordship, I am a new industrial undertaking under the NEIIP, Lordship. Lordship, Northeast Industrial Promotion Policy 2007, Lordship, was announced on 1st of April 2007.
Yes.
Which is at Annexure 1, page 26.
Yes.
It provided, among other benefit, Lordship, in this case, we are concerned with excise duty benefit. So it contained many benefits to the dealers who are establishing their industry in the Northeast region. So apart from that, apart from everything, central excise was also given. Lordship, may kindly see at page 26, the policy which is there.
Yes.
At
page
26, Annexure 1, the policy is there. 26.
Annexure 1, the policy is there. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26 Yes, please.
Lordship, it says duration. All new units as well as existing units which go in for substantial expenses unless otherwise specified and which commence commercial production within the 10-year period from the date of notification of NEIP will be eligible for incentives for a period of 10 years from the date of commencement of commercial production. Lordship, so 10 years they will get from, so it's since it is issued on 1st of April 2007 till 2017. If they commence a new unit or as well as existing unit, which will go in for substantial expansion, will get the benefit. Neutrality of location, incentives will be available to all industrial units as well as existing units on their expansion located anywhere in the Northeast region. Consequently, so and so. Lordship, thereafter, next page, Lordship, the excise duty exemption is also there and substantial expansion is also there. Lordship, I'll read point 4 and 5.
Yes.
Incentives on substantial expansion will be given to units effecting an increase by not less than 25% in the value of fixed capital investment in plant and machinery for the purpose of expansion of capacity as against incentives by so and so. Excise duty exemption, 100% excise duty exemption will be continued on finished products made in the Northeast region as was available under NEIP 97. However, in cases where Senate paid on so and so, Lordship, that is not relevant to our matter. So, Lordship, this NEIP was Lordship announced. Lordship, firstly, Lordship, I established my industries being inspired by this policy. I gave a statement at page 11 that I went into commencement of commercial production on 1/4/2008. 1/4/2008 initially, Lordship, as a new industrial unit. Page 11, Lordship, my statement is there. And Lordship, thereafter, they have substantiated with their order that my as a new industrial unit, I commenced my commercial production on 1/4/2008. I got a 10 years Lordship exemption at that point of time. That is not in dispute and there is no question on this. Lordship, thereafter, what had happened that I increased my installed capacity in my existing unit, which was established on 1/4/2008. And the date of commencement of commercial production for this substantially expanded unit was 1/2/2012, which is the subject matter of dispute in this instant case. 1/2/2012, I made a substantial expansion.
Yes.
Now, Lordship, after making a substantial expansion, I applied for a Lordship incentives to the government. Lordship, they have Lordship, they passed an order, but before that, Lordship, I skipped the notification. Lordship, page 31 is the notification. Page 31 is the notification because to give effect to the industrial policy, Lordship, a notification has to be issued. So they have issued a notification at page 33 is the relevant portion. Page 33, paragraph 5.
Yes.
The exemption contained in this notification shall apply to the following kinds of units, namely, number 1 is new industrial unit which commence commercial production on or after 1st day of April, not than 31st day of March, that I have already got firstly. Then industrial unit existing before 1st day of April 2007, but which have undertaken substantial expansion by way of increase by not less than 25% in the so and so. So, Lordship, I was not an industrial unit existing before 1. I have established after 1. So, Lordship, the expansion, substantial expansion is given only to this. So, my thing is silent in this regard because they have not said anything. Finally, point number 6, exemption contained in this notification shall apply to any of the said units for a period not exceed 10 years from the date of publication of this notification or from the date of commencement of commercial production, whichever is later. So, Lordship, when I applied at page 35, Lordship, they gave me a order.
Yes.
They reproduced the paragraph 5 of the notification and then they, Lordship, next page 36, they say,
yes.
From the above, it can be concluded that for availing exemption under notification number, you come under para 5A. That is a new industrial unit.
Yes.
Of the above mentioned notification as a new industrial unit. Therefore, in spite of having undertaken substantial expansion, so it is not in dispute, I have taken. They have accepted, which increased your production capacity from existing so-and-so to so-and-so. You remain eligible to get benefit of exemption in terms of notification so-and-so as amended with effect for 1/4/2008 only for a period of 10 years from the said date. So this is the rejection order I got, Lordship. Thereafter, Lordship, there was a circular issued by the notification. Lordship, my understanding of the thing was that once you have got an exemption under the new policy, you cannot get it second time, new industry as well as old industry ones. Lordship, this circular said that second time also you will get. Lordship may kindly see at page 40, the question answer which they have answered. Point number 3. Page 40, point number 3.
Yes.
A doubt has been raised with reference to the area-based excise duty exemption for the Northeast region, including Sikkim, by notification number so-and-so dated so-and-so, as to whether an industrial unit which is presently availing the excise duty exemption again undertakes substantial expansion by not less than 25% before 31/3/2017 and satisfy the conditions as stipulated under para 5 and 6 of the said notification, will again be eligible for excise duty exemption from such expanded capacity with effect from date of commencement of commercial production for a further period of 10 years. It is clarified that in absence of a provision to the contrary, the area-based exemption presently available in Northeast, including so-and-so, will be available to an existing unit on substantial expansion as well, provided that the unit commences commercial production from such expanded unit not later than 31/3/2017. Lordship, to seeing this, Lordship, I again applied that you are giving to the old industries again, so you can give to me also. Again, Lordship, I applied, and again, Lordship, an order was passed on 24/3/2017. Page 42, Lordship. Lordship, third paragraph I will read first, then fourth. For in view of the above, Lordship, they have firstly, in first two paragraphs, they have said that you have earlier also applied. In view of the above, it is reiterated that your unit being a new industrial unit and falling under para 5A of the notification is entitled to get the benefit of exemption for a period not exceeding 10 years from 1/4/2008, that is the date of commencement of commercial production of the unit. Further, it is clarified that para 5B of the notification is applicable only for those industrial units which existed before 1/4/2007. It is a condition precedent and your unit cannot fulfill the same as the unit commenced commercial production with effect from 1/4/2008. So accordingly, your exemption cannot be allowed. Claim of exemption for my expanded unit cannot be allowed. Lordship, thereafter, Lordship, they have filed an affidavit in this case.
Yes.
Now I'll go straight away to the affidavit. What is their stand in this case, Lordship? Lordship, in their affidavit at paragraph 9.
Yes.
Paragraph 9, Lordship, there is a subpara. First, although, paragraph 9, page 4. Lordship, although the NEIP confers benefit of exemption. So, Lordship, the policy confers benefit of exemption.
Paragraph 9.
Paragraph 9, Lordship.
Yes.
Subpara, Lordship, although the NEIP.
Yes.
Although the NEIP confers benefit of exemption to existing as well as new industries on their substantial expansion, but notification number 2020/2007. So they accept that Lordship, industrial policy is giving me the benefit, but notification 20/2007 by which the policy was implemented with clear stipulation of the procedures to avail the benefit by categorizing units into two sections under 5A for the units which has commenced commercial production on or after 1/4/2000 and under 5B for the existing units before 1/4/2007 but have undertaken a substantial expansion and commenced commercial from such expansion capacity after so and so. The unit in the instant case fall under the category of 5A, which is a new unit. So this is what is then the notification does not contain. Lordship, then paragraph 10, in the paragraph 10, they say that the deponent begs to state that policy framing and its implementation are being done by the agencies designated by the Government of India and have power and authority to issue necessary notification or clarification as and when required.
Yes.
And paragraph 12, they say the deponent begs to state that there is no statute or guiding instruction in this issue. And therefore, there is no ambiguity. So since they don't have any guiding instruction, even though the policy provided for the same, but the notification till now has not come, which is providing for this, Lordship, so far as new industrial units going for substantial expansion. So, Lordship, my short case is that since policy provides it to me and the notification may have taken it away, because Lordship, sometimes happens that because of supervening public interest, they take it away. Lordship, the Supreme Court has held that supervening public interest, they can take it away. But in this case, Lordship, they have not taken it away. It is that it is silent. So far as my thing is concerned, they have neither rejected it nor have implemented it. Nothing is there. because the agency have not failed to implement it, Lordship. So, Lordship, what will be the position of law in this regard when this type of, in my humble submission, Lordship, may I place your Lordship the law which has been mentioned in this regard, the compilation which is there. Lordship, in this compilation, I have even though given all the judgments from Motilal, Padam, Pad, Suprabhat Steel, all the judgments are there. Purnami Lordship knows about all these judgments, Pavan Milloys. But Lordship, I will take your Lordship to page 183. This is a recent judgment of Supreme Court which deals with the issue which is there, because other issues are relating to promissory estoppel only. But when the statute is silent, those are cases when the policy is giving, the notification takes it away. Most of the cases are. But Lordship, page 183 is the judgment wherein when the notification is silent, what happens? The rule of promissory estoppel as well as legitimate expectation, Lordship. Page 183, Lordship. This is the case of, Lordship, State of Jharkhand versus Brahmaputra Metallics Limited, Ranchi. Lordship, this by Justice Chandrachud. Lordship, this has dealt with all these judgments. Motilal Padampar, which I have given a compilation of. All these judgments are referred to in this judgment. Lordship, may kindly, I'll read first the head note, and thereafter I'll take you, Lordship, to all the paragraphs. Administrative law promissory estoppel, applicability, exemption promised by state in its industrial policy, failure or delayed issue of notification enforcing it. Besides, informants made retrospective liability of state under promissory estoppel doctrine. So this is the issue, Lordship, so far as this is concerned. This case is concerned. Lordship, first of all, Lordship, I would like to your Lordship to take your Lordship to page number 197. What is the issue in this case? Paragraph 4. So short paragraph is there which says what is the issue. Page 197, paragraph 4.
197.
197. Paragraph 4 is the paragraph. The issue for determination is whether the respondent is entitled to claim a rebate or deduction of 50% of the amount assessed towards electricity duty for financial year so-and-so. The respondent claims its entitlement on the basis of industrial policy and a statutory notification issued under so-and-so. The Bihar Act was adopted with effect from so-and-so in the state of Bihar under the provisions of Bihar Reorganization Act. So, Lordship, this is the issue which is there. They are claiming electricity duty. Lordship, thereafter, Lordship, I will take your Lordship that towards the discussions which has been made. Lordship, may kindly see the page under 206. 206. 206, Lordship, 27, page 27, para 27.
Yes.
Before promissory estoppel, origins and evolution. Before the High Court, the state of Jharkhand sought to sustain its action on the ground that though the follow-up notification under so-and-so was issued later, in this case, Lordship, it was issued, but later on it was issued, no outer limit for issuance of a notification was prescribed, and there was no vested right on the part of the respondent to get the notification implemented or to obtain the benefit of the policy until it was implemented by a follow-up notification. The decision in Kalyanpur Cement was sought to be distinguished on the ground that in that case, no follow-up notification has been issued at all. I will rely on Kalyanpur also, Lordship, until the policy lapsed. In sum and substance, the objection was that the writ petitioner, the respondent here, had no vested right to claim that a follow-up notification should be issued and the doctrine of promissory estoppel would not in the effects apply. This is a Lordship doctrine of promissory estoppel they have given. But Lordship, after that, paragraph 28 and other paragraphs deals with English law of promissory estoppel. Lordship, the Indian law, Lordship, it comes at page paragraph 32. India, Lordship. So paragraph 32 say that now India is starting because before that English law was there.
Yes.
Lordship, paragraph 33. This court has given an expansive interpretation to the doctrine of promissory estoppel in order to remedy the injustice being done to a party who has relied on a promise. In Motilal Padampa, this court viewed promissory estoppel as a principle in equity, which was not hampered by the doctrine of consideration, as was the case under English law. This court, speaking through so-and-so, held, having regard to the general operation to which doctrine in consideration has been subjected by eminent jurists, we need not be unduly anxious to protect this doctrine against assault or erosion, nor allow it to dwarf or stultify the full development of the equity of promissory estoppel, or inhibit or curtail its operational efficacy as a juristic device for preventing injustice. We do not see any valid reason why promissory estoppel should not be allowed to found a case of action when, in order to satisfy the equity, it is necessary to do so. Lordship, thereafter, from estoppel to expectations, legitimate expectation. So, Lordship,
Madam, we'll go to the case laws. First, what is your foundation?
Lordship, my foundation is that.
See, your unit is after the date of the NEIIP, that is 1/4/2007.
Yes, Your Lordship.
So you are a new unit.
You
have been given the exemption for 10 years as a new unit under this policy.
Yes, Your Lordship.
And this, as you have already stated, this is with regard to the excise duty benefit. Now, your case is that you had expanded after a particular period.
Yes, Your Lordship.
And this expansion may be more than 25%.
Yes, Your Lordship.
So you say that you should be given another benefit.
Another benefit or for
One other benefit because you come within the policy
Yes,
of NEIIP.
Yes, Your
Because it contemplates two things: one new unit, one existing unit who goes for an expansion of more than 25% of fixed capital.
Yes, Your Lordship.
So you said that though you have been treated as a new unit, given the exemption, after the expansion, you should be given another benefit
is
for
my-
10 years.
That's my-
That is your
That's-
case. And what is that basis? That document at page, is it page 11?
Lordship, Lordship, the documents were Lordship, they have said that while rejecting my claim, they say that the notification is not providing it. Lordship, may kindly see page 42, which is more clear.
Rejection we have seen, then clarification page 40.
The clarification. Lordship, clarification, Lordship, I'm relying on the clarification, Lordship, that there was a doubt that whether a doubt has been raised, Lordship,
So
page 40.
you are banking your entitlement on this page 40, paragraph 3, isn't it?
Not just this, Lordship, not just this. There is another thing, Lordship, that since if they say that the notification has not been issued in this regard, that you are not entitled because 5B says only to the old industry and 5A says to the new industry, you don't fall under any of the thing. I also say that if that is the case, then the notification is silent. And when notification is silent, but neither rejecting my claim nor granting my claim, so at least I should be entitled to the claim and what the law says in this regard. That
Now, let us see the clarification part at page 40.
Clarification is at page 40. Page 40, Lordship, point number 5. Point number 3, sorry.
3.
3.
A doubt has been
Raised.
This is by whom?
This is, Lordship, this clarification is by the Ministry, Ministry of Finance, Department of Revenue, Government of India. Page 37, it starts.
37, okay.
It clarified certain confusion which people had.
Let us read this. A doubt has been raised with reference to the area-based excise duty exemption for any region including so and so. Wide notification of 20/2007 CE dated 25/4/2007. This is
policy.
25/4 is page 31, isn't it?
Yes, Your Lordship.
This is notification 20/2007. 20/2007 CE, Central Excise. Okay. As to whether an industrial unit which is presently availing of the said excise duty exemption again undertakes substantial expansion by not less than 25% before so and so and satisfies the condition as stipulated in 5, the said will again be eligible for excise duty and so on, so on, so on, so on, so on. It is clarified that in absence of a provision to the contrary, the area-based so and so for which will be available to an existing unit on second substantial expansion as well, provided that the second concerned unit commences commercial production from such expanded capacity not later than 31/3/2017. That is after the expiry of 10 years.
Yes, Your Lordship.
Yes.
Hmm.
So this clears your problem.
Lordship, no, it's not clearing my problem.
No, this says you are entitled.
Not clearly, Lordship, because they have put a fetter also.
What is the fetter?
The fetter is that when it says that and satisfy the conditions as stipulated under para 5 and 6.
Yes.
This is the fetter, Lordship. So, Lordship, I have to
No, it is
satisfy
clarified and satisfied the condition not less than 5 and 6.
and
Where is 5 and 6? Para 5.
para 5 and 6 is at para 5 and 6 are at page 33.
30?
3. I may not satisfy 5, I satisfy 6, not para 5, Lordship. Para 5 again they put me into that same. New industrial units which commence commercial production on or after, but not later than so and so. Industrial units existing before the first day of April.
No, we have read 5. The exemption contained in this notification shall apply only to the following kinds of unit. Okay, number 1, new industrial units which commence commercial production on or after first day of April 2007. That is the date of the notification. But not later than 31st of day of March 2007. That 10 years period,
within
the
which
commercial production has to start. Then 10 years, you will get the benefit.
I have done it, Lordship.
You are getting it.
Yes.
No problem. Industrial units existing before 1st of April 2007. That means you have to be an industrial unit which were existing before the commencement of the policy. And you have made an expansion which is more than 25% of the fixed capital.
Yes.
Then also you'll be getting.
Yes, Lordship.
Now,
these are the two conditions.
Now you are admittedly a new unit. You got the thing.
Admittedly.
Now if you get expansion, you cannot be treated as a new unit. Existing unit. You are a new unit.
Yes, Your Lordship.
So how do you overcome this?
Lordship, per point 6 says the exemption contained in this notification is applied to any of the said units for a period not exceeding 10 years from the date of publication.
Yes, any of the said unit. To get the benefit of expansion, you need to be an existing unit prior to 1/4/2007. Which you are not.
Lordship, but the policy gives benefit to me also. When policy is giving.
You have already got the benefit.
Lordship, the policy gives benefits of substantial expansion also to me.
Expansion to whom?
To the new industrial unit also.
To an existing unit before 1/4/2007. Matter is very clear.
This is notification. This notification is clear. This is notification which, but when the policy was issued, it was not said that new unit will not get on substantial expansion. That
no, let us see the policy.
Yes, Your Lordship.
The same language. Policy.
Lordship.
At page 26.
Page 26, point number 2.
Yes. New so and so and the same.
All new units as well as existing units which go in for substantial expansion. So they give to both the units, new as well as, and that is why the Lordship there in their affidavit also they said that you will get, policy is giving to you, but there is no notification in this regard. In their affidavit also they state that new as well as existing.
Which policy, which paragraph are you reading?
Lordship, page 26, point number 2, duration.
Duration. All new units as well as existing units which go for an expiry unless otherwise specified and which commence within the 10 years so will be eligible for incentive for period. All new units.
And Lordship, in their affidavit also, let's say, when
there is any discrepancy between this office memorandum of 1st of April 2007 and the notification 20 of 2007.
Lordship, in their affidavit also they say that exemption to existing as well as they have clarified this. That although the NEIP confers benefit on existing as well as new units on their expansions.
Yes.
So they have accepted that new unit will get an expansion under the policy. But
yes, Mr. Kyle, what do you say?
But if the notification is very clear.
No, what Madam is saying that in your affidavit, you seem to have made a concession that even a new unit which has made a expansion.
Lordship, please to see preceding paragraphs. Paragraph 5. Only reading a line, Lordship, that will not do.
Paragraph?
Paragraph 5 onward. Page 2.
Just a minute, please.
So one thing is admitted, they are getting exemption under clause 5A. They
Yes.
are already availing, Lordship. Paragraph 5, may I read, Lordship?
Paragraph 5, yes.
Yes. That with regard to the statement made in paragraph 9 and 10 of the writ petition, the opponent state that the petitioner company fulfill the conditions contained in NEIPP 2007 and para 5A of the notification number 20 of 2007 dated so and so. And consequently, they have been availing the benefit of exemption by way of refund of excise duty paid through PLA. The unit commences commercial production with effect from 1/4/2008. That date is to record to be noted, Lordship. Where which is a new unit but not an existing unit in terms of para 5B of the notification number so and so.
Yes.
Then paragraph 6.
Yes.
The statement made in paragraph 11 and 12 of the writ petition are not correct. The deponent begged to state that although they had applied for eligible certificate for availing exemption from duty as expanded unit, the then Assistant Commissioner Central Excise Guwahati rejected their plea because the unit comes under para 5A of the notification number so and so as the unit commenced their commercial production with effect from 1/4/2008 and para 5 of the said notification dated so and so categorically states of two types of units to be eligible for exemption from duty, that is para 5A new units and para 5B existing unit which has commences commercial production before 1/4/2007. So Lordship, the policy is very clear. Lordship, I want to draw your Lordship to the paragraph 5, page 33.
Yes.
Paragraph 5. The exemption contained in this notification shall apply only to the following kinds of units, namely A. The new industrial units which commences commercial production on or after first day of April 2007, but B. Industrial units existing before 1/4/2007, but which have undertaken substantial expansion by way of increase by not less than 25% in value of the fixed capital investment in plant and machinery for the purpose of expansion of capacity modernization and diversification and have commenced commercial production from such expanded capacity on or after first day of 2007, but not later than 31st day of March 2007. There is no ambiguity, Lordship. Everything is clear. Lordship, to support my contention, Lordship, I am relying on two judgments of Honorable Supreme Court.
No, what she is trying to contend is that you have contemplated two situations.
Lordship.
One is a new unit which starts its commercial production after 1/4/2007. And the other, an existing unit which expands, carries on substantial expansion of not less than 25% on fixed capital.
Lordship.
So the second one is with regard to existing unit. That means a unit which was having commercial production prior to 1/4/2007. But the policy does not say of anything regarding a new unit which goes on for a substantial expansion within this period.
Let's see the opening paragraph of the notification. Page 31.
Yes.
Notification number 20 of 2007. In exercise of power conferred by the subsection 1 of section 5A of Central Excise Act 1944, the central government being satisfied that it is necessary in the public interest to do so, hereby exempt the goods specified in first schedule to the Central Excise Tariff Act 1985, other than those mentioned in annexure and cleared from units located in the state of Assam or Tripura or Meghalaya or Mizoram or Manipur or Nagaland or Arunachal Pradesh or Sikkim, as the case may be, from so much of the duty of excise leviable thereon under the said act as is equivalent to the amount of the duty paid by the manufacturer of goods other than the amounts duty paid by the utilization of Senbet credit under Senbet credit rule 2007. 2. In case where all these goods produced that is not necessary, Lordship, and section 5A is very clear. And the police has empowered the department to issue notification, Lordship. The notification is very clear. There is no ambiguity in the notification. The section clause 5A and B clearly stated that the existing units, they are the new units. So they are availing exemption, Lordship. And clause B, they are not fall under clause B because they start their production 1/4/2008, much before the Lordship the date specified in the notification. And Lordship, to fortify my argument, Lordship, I want to place two judgments in the Honorable Supreme Court.
Regarding what?
Regarding Lordship interpretation of the clause of the notification, exemption notification. I'm reading as supply the copy to you, Lordship, paragraph 14. Where an exemption
What is the citation?
Lordship, this is citation of Supreme SC 2022
2022
0 Supreme SC page 38.
name?
Name is State of Gujarat versus Aerosolar Mittal Nippon Steel India Private Limited
Versus
Aerosol ARCELOR ARCELOR Mittal MITTAL Nippon NIPPON Steel India Private Limited. Judgment was pronounced on 21/1/2022.
What is the proposition?
I'm just placing paragraph 14.2. It is settled law that the notification has to be read as a whole. If any of the conditions laid down in the notification is not fulfilled, the party is not entitled to benefit of the notification. An exemption and or an existing provision in taxing statute should be construed strictly, and it is not open to the court to ignore the conditions prescribed in industrial policy and the exemption notification. 14.3. The exemption notification should be strictly construed and given meaning according to the legislature intent. The statutory provision provided for exemption has to be interpreted in the light of words employed in them, and there cannot be any addition or subtraction from the statutory provision. Then, Lordship, another judgment on the same line. It is reported in SCC also, 2022 5 SCC, page 62.
2022
22 5 SCC, page 62.
name?
Name is Krishi Upaj Mandi Samiti. Krishi Upaj Mandi Samiti, New Mandi Yard, Alwar versus Commissioner of Central Excise and Service Tax. Let's see paragraph 8. Paragraph 8. The exemption notification should not be liberally construed, and benefit must fall within the ambit of the exemption and fulfill the condition thereof. In case such conditions are not fulfilled, the issue of application of the notification does not arise at all by all implications. It is settled law that the notification has to be read as a whole. If any of the conditions laid down in the notification is not fulfilled, the party is not entitled to the benefit of that notification. An exemption and or an exempting provisions in a taxing statute should be construed strictly, and it is not open to the court to ignore the conditions prescribed in the relevant policy and exemption notification issued in this regard. The exemption notification should be strictly construed. Same proposition has been laid down in this case. So, Lordship, the notification is very clear. It was issued by the competent authority, and the condition has been prescribed. They are availing the Lordship exemption under clause 5A. Now, when they are not falling under, they are interpreted differently, Lordship. And the notification is very clear. There is no silent condition is there, Lordship. Everything is clear, Lord. And admittedly, the unit was it started its commercial production from 1/4/2008. Lordship. So they fall under clause 5A, not under 5B. And in affidavit, Lordship, in further Lordship, in paragraph 9, my learned friend has placed one part of notification, paragraph 9 of my affidavit, Lordship.
Yes.
Paragraph 9, page 4. That regarding a statement made in paragraph 16 to 21 of the writ petition, the deponent begged to state that the Government of India under Ministry of Commerce and Industry and Department of Industrial Policy and Promotion adopted a policy under NEIPP 2007, which was subsequently implemented by said notification number 20 of 2007, dated 25/4/2007, with guidelines stipulated therein for availing the benefit. The department is legally bound to keep itself restricted to the guideline as prescribed by the notification. Although the NEIPP confers benefit of exemption to existing as well as the new units on their expansion, but notification number 20 of 2007, by which the policy was implemented with clear stipulation of the procedure to avail the benefit by categorizing units into two sections, that is clause under 5A of the units which has commenced commercial production on or after 1/4/2007, and clause 5B of the existing units before 1/4/2007, but have undertaken substantial expansion and commenced commercial production from such expansion capacity after 1/4/2007. The unit in the case falls under the category 5A, which is a new unit. NEIPP is a policy adopted by the Government of India, Ministry of Commerce and Commerce Industry, and under Department of Industrial Policy and Promotion. And the said policy was implemented by notification number in affidavit or in the notification or in the rejection letter. In affidavit or in the notification or in the rejection letter. Page 42. Letter dated 24/3/2017. Please refer to your letter number so and so on the above subject, wherein it has been requested to allow excise duty exemption to your unit with effect from 1/2/2012 in term of para 5B of the notification number so and so, as amended on the ground that the unit has undertaken substantial expansion by way of increase by not less than 25% of the value fixed capital investment, plant and machinery as required under the said notification. It is on record that the application in this regard has already been submitted by you to the then Deputy Commissioner of Central Excise Guwahati Division on 6/3/2012, and your claim of exemption as an existing unit was denied on the ground that your unit was already availing excise duty exemption with effect from 1/4/2008 as a new unit in terms of para 5A of the said notification. In view of the above, it is reiterated that your unit being a new industrial unit and falling under clause 5A of the said notification as entitled to get the benefit of exemption for a period not exceeding 10 years from 1/4/2008, that is the day of commencement of commercial production. Further, it is clarified that para 5B of the said notification is applicable only to those industrial units which has existed before 1/4/2007. It is condition precedent that your unit does not fulfill the same as the unit commences commercial production with effect from 1/4/2008. The clarification given in the unit budget, Indian budget 2016, and by DOF number so and so, dated so and so, and referred in your said letter dated 22/7/2007, relates to exemption duty to an existing unit on second substantial expansion. Accordingly, your claim for exemption duty in term of para 5B of the said notification state cannot be allowed. So Lordship, everything is clear, Lordship. The notification.
What is this last line? The clarification given in the Union Budget 2016.
Yes, Lordship. That has been placed before Lordship. That is annexed as Annexure 4, page 37. Clause 3 was placed before Lordship by my learned friend Lord.
Oh, yes, the clarification is there. It is very clear.
Yes, Lordship. very
Last
clear.
part will be available to an existing unit.
Yes, Lordship.
Existing unit cannot be an unit which it commences production after 1/4/2007.
Yes.
It is the unit prior to that.
Yes, prior to that.
Even if you go for a second expansion, then all you will get.
Yes, Lord. And Lordship, in the Supreme Court, in case of Dilip Kumar and Company, paragraph 66, clearly stated.
But if you are giving to an existing unit a second exemption, why not to a fresh unit?
Lordship, because they doesn't fall under this notification 20 of 2007, clause 5B and B is very clear, Lordship.
Existing unit.
Yes, Lordship.
Suppose an existing unit which had commenced production prior to 1/4/2007.
Then they will
Within
get
10 years,
they
they
will-
go for two expansion. First expansion within first year or first 5 years, they get 10 years. And before expiry of 2017,
Then
they
they-
go for,
they
they'll
will-
get another benefit.
They will be entitled, Lordship, as per the clarification. But Lordship, the present petitioner, being in an industrial unit, the new unit, they are availing exemption under say clause 5A. Now they are claiming the benefit under clause B also. How it can be allowed, Lordship? And the notification is very clear. And the Supreme Court, time and again, said that the policy, the exemption notification should be interpreted strictly, Lordship. And there is no ambiguity in the notification dated Lordship 20 of 2007. It's very clear, Lordship. If there could have been any ambiguity, then Lordship, question of interpretation would have been arise.
Okay. We'll
Lordship, in Dilip Commercial, Lordship, paragraph 66. I'll supply copy to you, Lordship. This is 2018 9 SCC, page 1. 2018 9 SCC, page 1. Paragraph 66.
Name?
Name of the party is Commissioner of Custom, Import, Mumbai versus Dilip Kumar and Company.
Okay.
Paragraph 66.
Yes.
It says that to sum up, we insert the reference holding as under 66.1. Exemption notification should be interpreted strictly. The burden of proving applicability would be on the SEC to show that he comes within the parameters of the exemption clause or exemption notification. Where such ambiguity is in Lordship, then Lordship, this also been answered by this by this judgment. When there is an ambiguity in exemption notification, which is subject to strict interpretation, the benefit of the ambiguity cannot be claimed by the subject SEC, and it must be interpreted in favor of the revenue.
Yes.
Lordship, law is very clear in this case. Lordship, the petition is no case. They are availing exemption under clause 5A. So they are not entitled to claim exemption under clause B. This is my observation, Lordship.
Okay.
Lordship.
Okay, short reply.
Yes, Your Lordship. Lordship, my case is not, I'm not challenging the notification. I am accepting the fact that my notification is not giving me the benefit. So that therefore the judgments relied on by the respondents are saying that notification, strict interpretation, but I am accepting that notification is not giving me the benefit. I am only saying that the policy is giving me the benefit, but that has not been given to me by any by issuance of any notification. There is a silent. They don't say that by way of supervening public interest, whatever benefits I give to you in the policy, I will not give it to you. That is also not what they don't say, by that there is a supervening public interest. They have very categorically stated in their paragraph 9 that NEIP confers benefit of exemption to existing as well as new units on their expansions. So they have accepted that policy gives me the benefits.
Where page?
Page 4, para 9 in their affidavit. para 9, Lordship may see the para 9 of subpara, although the NEIP confers benefit of exemption to existing as well as new units on their expansions. So they are accepting that.
No, I think this is wrongly worded. This is wrongly worded. It should be giving exemption to new unit as well as existing unit on their expansion. I think you have used the wrong expression. Mr. Kyle, page 46.
Page?
46, although.
Yes.
Although NEIP confers benefit of exemption to existing
as well as the new
new units under expansion. This I don't think is the correct expression. Exemption to new units as well as existing units under expansion.
Lordship, page 26, all the new units as well as the existing units which go is in the substantial expansion.
That is it, new unit and existing unit for expansion. You have written existing as well as new units under expansion. What expression have you used?
But Lordship, in any NAP policy, it is stated like that, Lordship.
Your affidavit, you see, your affidavit gives a different meaning. Confers benefit of exemption to, you had written existing first, as well as new units under expansion.
Yes, Lordship, that
to be new units and existing units under expansion.
Yes. And Lordship, the opening paragraph 9 is to be taken into consideration. Lordship, only reading a paragraph which benefits to give benefits. I'm not admitting. If Lordship that
no, first opening paragraph will not help you. Paragraph 9, first paragraph is not going to help you.
Lordship,
please read.
Yes, with regard to the statement made in paragraph 16 and 16 to 21 of the writ petition, the deponent begged to state that the Government of India under Ministry of Commerce and Industry and Department of Industrial Policy and Promotion adopted a policy under NEIPP, which was subsequently implemented by notification number 2007.
Yes.
Dated so and so with guidelines stipulated therein for a billing benefit. The department is legally bound to keep itself restricted to the guideline as prescribed in the notification.
Yes.
This is our case, Lordship.
This is not the next paragraph. The first, the manner of expressing is not correct. If you are trying to mean that the policy is only for new and existing on expansion, you have written here existing and new on expansion.
Although the NEPC confers benefit of exemption to existing as well. Wording is otherwise meaning, Lordship, if we go strictly, then Lordship
No, if you read only this paragraph,
Lordship,
it might may have a different meaning, but you cannot, of course, ignore the main policy statements in the affidavit. Maybe
sometime, Lordship.
In fact, the entire affidavit goes on to explain in this regard only, Lordship.
No.
The other paragraph also that policy is giving, notification does not give it to you. That way only the entire affidavit is made. So Lordship, even if we ignore Lordship, I'll rely on the affidavit. I'll rely on only two judgments which I have placed before your Lordship, one and another judgment. I'll give the paragraph numberings, Lordship.
You have placed State of Jharkhand.
State of Jharkhand versus Lordship.
The other one, any
Lordship, my only the other one is Kalyan. State of Jharkhand versus Brahmapur Metallics Limited, which is 2023 10 SCC.
That we have already said.
634.
Yes.
My Lordship prayer is that when the notification is silent and you have given a promise, that has to be implemented and therefore the benefit has to be given. If you have not implemented it, even Lordship, the Kalyanpur Lordship, the judgment which I've given Lordship, this is 2010 3 SCC 274, State of Bihar versus Kalyanpur Cement Limited, Lordship, para 71 and 85 I will be relying.
71
and 85. '71 gives the Lordship the factual background of the case, and Lordship paragraph 85 gives the Lordship the substance of the judgment. 83, 84 and 85. Lordship, may I read these two paragraphs only?
Yes.
Lordship, paragraph 71 says, Lordship, before the High Court, the company had claimed that it was eligible to avail sales tax incentive for a period of 8 years. This incentive was necessary for the revival of the unit. It has been found to be eligible for exemption at the highest level of the government. The state government has held out a clear and unequivocal assurance and promise to the company, as also the financial institution, that the necessary notification under clause 24 of industrial policy would be issued. Assurances, promises are contained in official documents. So it was therefore submitted that the government cannot be permitted to resile from its representations. Then, Lordship, thereafter, all this has been discussed. All the judgments, Lordship, which I have relied on in my paper book. Paragraph 85 finally says, it is inconceivable that it could have taken the government 3 years to issue the follow-up notification. We are of considered opinion that failure of appellants to issue the necessary notification within a reasonable period of enforcement of industrial policy has rendered the decisions wholly arbitrary. Appellant cannot be permitted to rely on its own lapses in implementing the policy decision to defeat the just and valid claim of the company. For the same reason, we are unable to accept the submission of the learned senior counsel for the appellant that no relief can be granted to the company as the policy has lapsed. Accepting such a submission would be to put a premium and accord a justification to the wholly arbitrary action of the appellant in not issuing the notification giving the effect of the policy in accordance with the provisions contained in clause 24 of the Industrial Policy 95. So, Lordship, my humble submission will be that once the policy grants me the benefit of to industrial as well as to existing as well as the new industry on their substantial expansion. So, Lordship, by not giving the either you could have said no, I will not give you. You have not said that supervening public interest I will not give. But Lordship, once you have promised me, Lordship, by not implementing it through a notification is, Lordship, substantial, because notification is silent in this regard. Lordship, and I'll finally, Lordship, read only one thing, Lordship, that all new units as well as existing units which go for substantial expansion, there is no comma in between. Lordship, that has to be read. That the entire line means that all new and existing unit which go in for substantial expansion. Lordship, page 26, the policy which I am reading, so there is no comma in between. It says, and this fact has been accepted by them in their affidavit. Point number 2, all new units as well as existing units which go in for substantial expansion. So, Lordship, this is the full line which says that new units as well as the existing units which go in for substantial expansion. It does not say, and Lordship, there is no comma, so it will mean new unit as well as the existing unit which will go for substantial expansion will be entitled to. And Lordship may kindly see the neutrality of location, next paragraph also.
Madam, that interpretation cannot be available to you.
Lordship,
That means then all new units will not be eligible unless they go for expansion.
No, Your Lordship,
Yes, see, all new units as well as existing which goes for substantial expansion. That can be one meaning. Whether you are new or existing doesn't matter. Unless you go for substantial expansion, you are not going to get. That is not the. Then you cannot interpret.
That cannot be interpretation.
You have to interpret new is a separate existing with substantial expansion.
Otherwise, Lordship.
If your meaning is to be given, not a single new unit will get unless they go for expansion.
Otherwise,
would not have been the policy.
Lordship, otherwise this same is been given in 3 also. The same wordings, Lordship. Lordship, I'll leave it on your Lordship. Yes. Incentives will be available to all industrials, new as well as existing units on their substantial expansion. This also, over here also, Lordship, they say, it will be given to all industrial units, comma, new as well as existing unit.
New
on the
as well as existing units on their suspension.
Located anywhere. And Lordship, Lordship, my one more submission may kindly be accepted, that on 1/2/2012, when I went into substantial expansion, I was an existing unit at that point of time, even though
existing unit has to be defined in terms of 1/4/2007. That cannot be. You will not be an existing unit.
Yes, Your
you may have the first argument we have to consider whether an unit which is a new unit in terms of this policy, if it goes for an expansion during this period of 10 years and the notification is silent, can you claim that? That will answer.
Yes, Lordship. And secondly, Lordship, one more thing, Lordship, that is on equity I am saying, Lordship, because I cannot interpret that circular. Lordship, if a industry which is established before 2007, it is getting 2 times, 3 times, whatever expansions they are doing, they are getting. I have established immediately after coming of the policy. So, Lordship, I should also get the same amount because they are getting twice, thrice. I'm not getting, Lordship, I'm just getting on my new industry, not even a single expansion I'm getting. So, Lordship, that is
Madam, there's a huge difference. You get an exemption on the entire unit.
Yes, Your Lordship.
And so far as the existing, it gets only on the expansion part. So you are not at par. And that to expansion, which is more than 25% of the fixed capital.
Fixed capital, Lordship.
Any expansion will not do.
No.
So you are not at par, that they are getting more than once. You are getting on the entire unit. There's a difference. Okay, we'll consider.
Lordship, to give reply to my friend, Lordship, I am just placing one judgment, Lordship. 2020, volume 20, SEC page 57. 2020, 20 SEC page 57. The name of the party is Union of India.
2020?
2020.
20 SEC.
20 SEC. Page 57.
There are 20 SEC.
Yes, Lordship. In 2020, Lordship, there was 20 SEC.
10 SEC.
I'll provide
Cannot be 20 SEC.
Yes, Lordship, it is written here, Lord.
SEC's volumes runs to around 16, not more than that.
But in 20, Lordship, probably it is increased. In any way, Lordship, I'll provide
2020, 20 SEC.
Yes, yes.
Page?
Page 57.
Name?
Name of the party is Union of India versus BBF Limited and another. BBF
Limited. Okay.
Lordship, the entire concept of promissory estoppel has been discussed in this.
Paragraph?
Lordship, paragraph 11. There are subparagraphs 11.1, 11.2, 11.4, 11.5.
Lordship, can I explain this judgment? Because Lordship, in all the single bench, because it emanates from the Guwahati High Court. Lordship, in all the single bench and division bench I have appeared. Lordship, this is the same case wherein, Lordship, we had challenged the curtailment notification, where curtailment was done. Single bench we want, division bench we want, it went to the Supreme Court. Supreme Court says that in supervening public interest, you can take it away.
No,
Entitlement.
on the
Curtailment.
See, this case will be more on not on promissory estoppel. It's not that
Here
nothing has been given.
interpretation.
We are on the interpretation.
Interpretation. And Lordship, in the I cannot say the paragraph, but there is a gist in the written in the judgment. Doctrine of promissory estoppel cannot be invoked in abstract if an statute is curative or merely declaratory or previous law retrospective operation in general intended. Then 3, person claiming exemption has to establish that his case squarely falls within the exemption notification, and while doing so, a notification should be constituted against SEC in case of ambiguity. Earlier, that has been repeated in judgment.
Okay. Heard Ms. Anne Haveli, learned counsel for the petitioner. Also heard Sri Astika, learned senior standing counsel, Central Excise. Judgment hearing is concluded. Judgment is reserved.
Much obliged.
Madam, we'll hand over back this. There's no point. You can use this after on the delivery of judgment. We'll hand it over. We don't retain unless it is all wasted, but it will definitely come for your use in some other cases.
But I have a copy. Otherwise,
No, but no point again photocopying everything.
Yeah.
Will use whatever is required.
Yes, Your Lordship. Much obliged, Your Lordship. लैंडमार्क जजमेंट आएगा बढ़िया जजमेंट आएगा 5 ट्यूब में बात नहीं है